Good morning, everyone, and welcome to the First Amendment Law Review's Volume 21 Symposium, the First Amendment Jurisprudence and Justice Breyer. My name is Rachel Allure. I'm the editor-in-chief of the First Amendment Law Review, and I'm so happy to welcome you here today. We have very special people here today, and I cannot express the magnitude of this many brilliant First Amendment scholars in one room. I know I'm excited to learn from all of them, and I hope you are too. Before we get started, I wanted to thank everyone who listening today possible. First, I want to thank our wonderful panelists and moderators for traveling from near and far and taking time out of their busy schedules to be here. Thank you to the Carolina Club for hosting us today, and I want to thank the Fallon Board and staff for their help in planning and organizing this event. And special thanks to our advisors, Professors Papandrea and Arvia, for their invaluable guidance and support in making this symposium possible. Finally, thanks to our sponsors, the Center for Media Law and Policy, the Graduate and Professional Student Government, and the Federalist Society. We also want to thank the Program for Public Discourse and the Political Science Department for their support of this symposium today. To open our symposium, it is my honor to introduce Professor David Arvia, our Journalist Faculty Advisor. Professor Arvia serves as the Reese C. Ivey II Excellence Fund Term Professor of Law and Faculty Co-Director of the UNC Center for Media Law and Policy at the UNC School of Law. He also holds a secondary appointment at the UNC Hudson School of Journalism and Media. Before joining the UNC faculty, he was a fellow at the Berkman Klein Center for Internet and Society at Harvard University. He served as assistant counsel for the Washington Post, where he provided pre-publication review and legal advice on First Amendment, news gathering, intellectual property, and general business issues. Professor Arvia's research focuses on examining the impact of new information technologies on law and society, particularly the role that government and private intermediaries play in shaping the environment for speech and how legal and social forces affect these actors. If you all will join me in welcoming Professor Arvia.
Thank you, Rachel, for that gracious introduction, and thank you for all of your hard work at the end of this symposium. It's an enormous undertaking to make this day smooth and fair to the content of the back end of this. Thank you, Rachel. And thank you all for coming and spending your Friday with us, both here in person and also online. I'm going to tell you a little bit about Justice Breyer, but I'm also going to bring you back in time to 1994 to get a sense of what the world was like when he ascended to his place on the U.S. Supreme Court. Breyer served as an associate justice on the court for almost 30 years, stepping down, some would say finally stepping down, at the end of the court's 2021 term at the age of 83. Breyer's path to the Supreme Court reads like a highlight reel for a person destined to the nation's highest court. Breyer was born in San Francisco in 1938, attended Stanford University and the University of Oxford as a Marshall Scholar. He graduated from Harvard Law School in 1964 and went straight to a clerkship with Associate Justice Arthur Goldberg. After clerking, Breyer went back to Harvard, where he taught from 1967 to 1980. He specialized in administrative law, writing case books that are still used today. During his time at Harvard, Breyer also held a number of prominent positions in government, including as a special assistant to the Assistant Attorney General for Antitrust and Assistant Special Prosecutor of the Watergate Special Prosecution Task Force, 1973. In 1980, President Jimmy Carter appointed Breyer to the First Circuit Court of Appeals, where he served as Chief Judge from 1990 until his elevation to the Supreme Court in 1994. And Breyer was the second of President Bill Clinton's Supreme Court appointments, following Justice Ruth Bader Ginsburg's nomination in 1993. And it was widely reported at the time that Breyer was a finalist for that appointment that eventually went to Justice Ginsburg, and imagine he was disappointed. But he only had to wait another year as the retirement of Justice Mary Black gave President Clinton another opportunity to fill a vacancy on the court, and he nominated Breyer in May of 1990. The Senate confirmed Breyer by a vote of 87 to 9 to the Speaker. And Justice Breyer joined the board as Associate Justice in August of that year. Now, for those of you that were not alive in 1990, expect all of the students. So there were no smartphones, there were no iPads, there were no flash TVs, and imagine this: there was no Google, no Facebook, no Netflix. Only the year before, in April 1993, Tim Berners-Lee wrote the initial code that nearly all websites currently run. But his World Wide Web software, the public domain, making it available for others to build the internet. Now, instead of the open web, people used paid dial-up online services like American Online, known as AOL. In 1994, you paid for every minute you used it, and you installed AOL from a floppy disk, later on a CD, that you received unasked for in the mail. Hundreds of them, maybe I would receive a dozen a year. Obviously, you couldn't avoid finally sitting here if you don't think to try. The DVD wasn't invented until 1995. So in 1994, you watched recorded movies on VHS. You know what that is? That up. During this time period, the organization that took her over, Vice President Al Gore's wife, Coleman she founded an organization that banned record companies refraining from selling explicit music to children, focusing on popular artists of the day, especially Prince, AC/DC, Black Sabbath, Def Leppard, Cyndi Lauper, and these like my current famous people today. Well, they weren't successful in getting music banned, but they were successful in convincing the Recording Industry Association of America to adopt a scheme for warning labels that you still see on music today. In 1994, South Africa held its first multiracial elections at the end of apartheid. Nelson Mandela became the country's president. Also in 1994, O.J. Simpson, after fleeing police in his white Bronco on the famous slow-speed chase nonstop on CNN, was arrested for the killings of his wife, Brown Simpson, and friend Ron. Lastly, the average cost per gallon of gasoline in 1994, $1.09. But let's get back to Justice Breyer. During his 27 years on the court, Breyer offered 549 opinions, 214 majority opinions, 118 concurrences, 205 dissents. Breyer authored 35 majority opinions, 5 to 4 cases. And as of 2021, that placed him second among the active justices behind Justice Thomas, who had authored 40 such decisions. She joined the court in 1991, 3 years before. So perhaps it's not surprising given that Thomas is the longest serving justice in the court. But it might be more interesting to note that during his time on the court, Breyer was the sole dissenting justice in only 8 cases, whereas Thomas authored a dissent in 81 decisions 33 times during that time. In his final year on the court, Breyer had the highest agreement rate with Lena Kagan, joining her in about approximately 89% of the court's decisions. During the 2021 term, Breyer had the lowest overall agreement rate with Justice Thomas, joining him in only 48% of the court's decisions. Now, like you, I'm looking forward to hearing what our investigative scholars tell us today about Justice Thomas on the court's First Amendment, and what this extensive body of jurisprudence tells us about future challenges. So let me ask you to welcome Kendall Williams, Valor's Symposium editor, to come up and introduce our keynote speaker, Dean Erwin Jones.
Hello, everybody, and again, thank you all so much for being here. Before I introduce Dean Jurisprudence, I just want to go over a few housekeeping things. First, if you're here for CLE credit, please make sure you address that with the registration table outside at some point. They've got forms out there. Please make sure you fill them out and return them before you leave at the end of the day. Also, if you're joining us remotely, I will follow up with you after this, sending you paperwork you need to fill out and return to me in order to get that CLE. Second, whether you're in person or online, you can join the conversation on Twitter or Instagram using hashtag UNC Justice Breyer or hashtag FALR, First Amendment Law Review. We'd love to see how active this is. Second, we're going to run through the schedule for the day. So we're going to start with the address with Dean Jurisprudence. At the end of that, there will be time for questions, so please hold all questions till the end. After that, we'll go into our first panel, Breyer and freedom of expression. That'll be from 9:45 to 11:15. 11:15 to 12:15 we'll have lunch, and then launch into panel 2, Breyer and the religion clauses. After that, we will have a 15-minute break. And from there, panel 3, Breyer and future First Amendment challenges. Now, moving on to the Jurisprudence. Teacher Oransky has been the dean and the Jesse H. Chopper Distinguished Professor of Law at Berkeley since 2017. From 2008 to 2017, he was the founding dean and the Distinguished Professor of Law and Braden Wright Professor of First Amendment Law at the University of California Irvine School of Law. Before that, he was the Alston and Bird Professor of Law and Science at Duke University, who all hold that against him. And from 1983 to 2004, he was a professor at the University of Southern California Law School, including as the Sidney M. Ernest Professor of Public Interest Law, Legal Ethics, and Political Science. From 1980 to 1983, he was an assistant professor at DePaul College of Law, so he's been to many places. He's the author of 15 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. He's also the author of more than 200 law review articles. He frequently argues public cases, some of which are in the United States Supreme Court. In 2017, National Jurist Magazine again named Dean Jurisprudence as the most influential person in legal education in all of the United States. In January 2021, he was named President-elect of the Association of American Law Schools. So without further ado, please join me in welcoming Dean Jurisprudence.
Thank you so much for that kind introduction. It's really wonderful to be here. I'm really honored to begin this conference with some remarks. I think it's appropriate at this moment of time to focus on the jurisprudence of Justice Breyer. But I have to tell you that I have mixed feelings about beginning this conference with remarks. On the one hand, there's much I admire about Justice Breyer. Most of all, I admire his unfailing decency. At a time when Supreme Court opinions have increasingly filled with sarcasm and invective, he never resorted to caustic language. The decency was certainly evident. Every oral argument in treaty counsel. I had the privilege of arguing a number of cases in front of Justice Breyer. He was never a justice who asked the gotcha question. He was never the justice who used sarcasm or caustic language in oral argument. There was always the sense that he was asking exactly about what most concerned about the lawyer's position. That's what any attorney wants. So I have to say, like all attorneys, at times I was frustrated by his long, convoluted questions, because I wanted the minutes to get down and how much I have left, and I continue to speak for justice. I always admired his pragmatism, his bringing in real-world implications of Supreme Court decisions. And there are areas of his jurisprudence where I would read praise. I think his opinions on the Second Amendment, especially his dissent last June, the New York State Bar Association versus Bruin, who you beacon for justice in courts in the future. I would praise his abortion decisions, cases like Stenberg versus Carver, Women's Health versus Alexander, Medical Services versus Russo. I would praise most of all, perhaps of all you need to see about is dissenting opinion. Parents involved in these schools, for Seattle School District number 1, we very much defended the importance of diversity in education. But I have to tell you, one area where I'm not an admirer of Justice Breyer is with regard to the First Amendment of the Symposium. I think the responsibility of the Supreme Court is to provide clarity in the law, to give guidance to others that follow this decision. I think this is responsibility for to articulate clear tests, rules that can be followed by others. Most of all, this is important in giving guidance to lower courts. Last term, the Supreme Court decided 58 cases with signed opinions that could read no argument. For that was 54, for that was 52. With the court deciding so few cases, it means it's a minuscule amount of the decisions that are rendered each year. The rest are from the lower courts. It is the Supreme Court's responsibility to give them guidance with tested standards. The guidance is also important for elected government officials, legislators, federal and state, executive officials. It's important to give guidance to lawyers in terms of how they advise their clients. And I find Justice Breyer's First Amendment jurisprudence a failure to provide the necessary guidance. I see this both with regard to his religion clause jurisprudence and his freedom of speech jurisprudence. But I see the problems in each being different. With regard to religion clauses, we're going to talk about how some drawing arbitrary distinctions are often hard to figure out, certainly provide guidance to others. With regard to speech jurisprudence, it was a rejection of levels of scrutiny as embracing a proportionality test or balancing test that again I saw giving little guidance to others in the system. So we're discussing each of these in part. Let me begin with the religion clause jurisprudence of Justice Breyer, talking initially about the establishment clause and then about the free exercise clause. With regard to the establishment clause, one place where there's a body of jurisprudence of Justice Breyer is regarding when there can be religious symbols on government property. In two cases, in the spring of 2005, are especially important here. Mercury County versus ACLU, and then Orton versus Perry. Both involved Ten Commandments violations. Both were placed by the government on public property. In one, the Supreme Court found the violation of the establishment clause. In the other, the Supreme Court held that it didn't violate the Constitution. Now, it was notable about those cases that 4 justices would have upheld both Ten Commandments displayed. This was Rehnquist, Scalia, Kavanaugh, and Thomas. 4 justices would have invalidated both Ten Commandments displayed. This was Justice Stevens, Ginsburg, and O'Connor. Only 1 justice was the victorian in both cases, Stephen Breyer. So it is the approach that usually the law with regard to religious symbols on government property. This is the composition that we're taking. Now, as I describe these cases, I should make disclosure here. I was the lawyer who argued in Orton versus Perry on the losing side. Let me talk about the 2 cases. Mercury County versus ACLU involves counties in Kentucky that require that the Ten Commandments be posted in their buildings. The ACLU brought a challenge to this, and then the county said what to do is have 9 displays all about the role of religion in American history, all the same size, and one would be the Ten Commandments. The Supreme Court in a 5-4 decision on this violated the establishment clause. Just the pseudo-running opinion of the court. He described how the Ten Commandments are inherently religious. They come from the Bible, religious scripture. They begin with the words, I am the Lord thy God. First 5 commandments are profoundly religious, but religious practice and observance. The other case was Van Orton versus Perry. It involves a 6-foot-high, 3-foot-wide Ten Commandments monument. This is directly at the corner of the Texas Supreme Court and the Texas State Capitol. The argument was that for the government to put a profoundly religious symbol in the seat of government violates the Establishment Clause. I will tell you, as I wrote the brief in the case, as I prepared for oral argument, I was convinced that the case was going to come down to just standard of time. I knew I had no chances of getting the votes. Justices Rehnquist, Scalia, Kennedy, and Thomas. Their view of the Establishment Clause is that no religious symbol will ever violate the Constitution. They believe the government violates the Establishment Clause only if it enforces religious behavior. I also likely get the votes of Stevens, Souter, Ginsburg, and Breyer. And so my focus was on standard of time. My brief was a shameless attempt to pander to Justice O'Connor. If I could have Justice O'Connor picture on the mind. I got Justice O'Connor's vote, but I lost because Justice Breyer concurred in the judgment, providing the fifth vote to uphold the text and keep it monument. I have read his opinion many times, most recently yesterday, and I am still baffled by it. And he says many things. He says that the monument had been there since 1961, and no one complained except my client, Tom Stidham. Actually, that's not true. There are a number of other complaints about the monument. Looking back, I'm not sure I have manners no longer in there. Next, he says that it wasn't paid for by the state of Texas. Again, that's not in the record. I was asked about that in oral argument and said, it's unclear who paid for the monument. Many think it was paid for by Cecil B. DeMille in promoting his movie, The Ten Commandments. There's no records to be sure. And he says there's 20 other some monuments on the Texas State Capitol grounds, but there's no other religious monument. And this was a particularly important place, right at the Texas Supreme Court of the Texas State Capitol. Justice Breyer concluded his opinion by saying that the finding of the monument unconstitutional may not really religion. But any enforcement of the Establishment Clause could be thought of as hostility to religion. Why is this any different than McCreary County? Why was it finding the Ten Commandments displays in the county buildings hostility to religion? What makes this case different from McCreary County? Argued and decided the same day. The day these two cases came down, I heard a CNN commentator say the difference was in McCreary County, it was inside the building, whereas in Oregon, it was outside the building. They can't be the first principle. Jeffrey Tubin in the book said the difference was that one was an older monument, that would be in Oregon versus McCreary, whereas the other was a newer Ten Commandments display in McCreary County. In other words, the principle, we're not going to take down old monuments, but don't build new ones. I find that too hard to explain as a First Amendment principle, but then Justice Breyer made it explicit just a few years ago. The American Legion was their Humanist Association. That involves a 45-year cost that's such a busy intersection on public property in Maryland. And the Supreme Court found that it didn't violate the Establishment Clause, even though the clause is obviously a quintessential Christian religious symbol. Justice Breyer, in the concurring opinion, said was key to him is that he'd been there a long time. Now, again, as a principle that violates the Establishment Clause, I don't see why the age should matter. But I'm focusing especially on the guidance of lower courts. What's the principle for lower court judges? Is it 1 year, 5 years, 4 years? How are lower courts to implement this? Governments know what to do. Let me share and talk about history exercise jurisprudence. And here an inconsistency that I had more to explain, and if courts were to follow it, I'm not sure what guidance they could take. And this involves recent issues before the court of when can the government deny funding for religious schools providing only for private secular schools. In 2017, in Trinity Lutheran versus Comer, the Supreme Court considered a Missouri law that provided aid for schools for surfacing playgrounds. The Missouri law provides money for public schools and secular private schools that qualify, but not to religious schools. The Supreme Court, the 7-2 decision, found this violated the Constitution that it denied religious schools free access to religion. Chief Justice Roberts, with the opinion of the court, said, it's odious for government to give money for secular private schools, but not to give money to religious schools. Footnote 3 said, this is just a case about aid playgrounds, not a case about anything else. We know that's not how the law works. Justice Sotomayor really blistering dissent, saying, this is the first time in all of American history that the Supreme Court is required that the government might aid to religious institutions. But Justice Breyer joined that dissent. He wrote a concurring opinion saying that since this aid is generally available, it should be provided to religious schools as well as the secular ones. Now, there is a principle there that could guide lower courts. Let's skip ahead to this year, when the court decided Carson versus Megan on Tuesday, June 21st. This involves the state of Maine providing funds to parents to send their children to private schools in areas that are too rural for public school systems. There are parts of Maine that are too rural to the public school system. In these areas, Maine law said that the state would give money to parents to send their children to private school. About 5,000 children a year are affected by this. And the restriction is that the money can't be used for sectarian or religious schools. The lower courts have held this. The lower court said Maine has a compelling interest in providing free secular education for all children in the state. The lower courts have emphasized that the state has an interest in not taxing some people to support the religion of others. Justice Breyer wrote one of the two dissenting opinions. Justice Sotomayor wrote the other. Justice Breyer's dissent was powerful, stressing the establishment clause, stressing the divisiveness of the government subsidizing religious schools. But how can I reconcile that with his opinion in Trinity Lutheran? If one says it can be there, so long as the aid is generally given, why doesn't that then make the main program permissible? Now, maybe he's drawing a distinction between aid for a particular use, servicing playgrounds, as well as aid to go to school. But again, I would be hard pressed to make that a constitutional principle for where to draw the line. Let me shift then and talk about his free speech jurisprudence. And my ultimate criticism is the same: the failure to give adequate guidance. So the specifics are different here. Justice Breyer, in his free speech jurisprudence, has consistently rejected the application of levels of scrutiny, and particularly has rejected the use of strict scrutiny. And instead has embraced what he calls a proportionality test, or an interest balancing test. Let me just remind you of some of the cases, and then talk about why I find this approach problematic. It's something he said so as a time tenure on the court. In 2000, a case called Nixon versus Shrink Missouri Political Action Committee, the Supreme Court considered Missouri law to impose very strict limits on the amount of money that contributed in election campaigns. And Justice Breyer wrote an opinion where he said the appropriate way to approach free speech is proportionality analysis, not the levels of scrutiny. And he cited foreign practices. He said this is common and cited ruling of the International Commission on Human Rights and the decision of the Canadian Supreme Court. And there are other places in his free speech decisions where he cited the foreign practices where proportionality analysis is used. But he didn't give much guidance in terms of how to decide if a particular regulation is disproportionate. I think perhaps one of the most important decisions with regard to free speech was a dissent in 2011 in Sorrell versus INS. This involved a Vermont law that limited the ability of pharmacies to give certain information out with regard to prescriptions that had been issued. It was important to play this unconstitutional. Justice Breyer wrote the lengthy dissent. It's the first time that the justice talked about the First Amendment being used like locker to strike down social regulation. Justice Kagan later picked up this phrase in Janus versus American Federation, which talked about the lockerizing of the First Amendment. Here, Justice Breyer again said that the appropriate test should be one of proportionality. Is the government regulation disproportionate to the problem that it's solving? But the concern that I have with that is how is it decided what's disproportionate and when something violates the speech clause of the First Amendment? Another of his most famous opinions in this regard came the next year in 2012 in the United States versus Alvarez. This involved a federal law, the Stolen Ballot Act. It made it a federal crime for a person to falsely claim to receive military honors or decorations. Javier Alvarez, at a government meeting in Southern California, is falsely claimed to receive Congressional Medal of Honor. The Supreme Court 6-3 invalidated the Stolen Ballot Act. Justice Kennedy wrote a plurality opinion before, but Justice Breyer wrote an opinion during the judgment signed by Justice Kagan. And in it, he very much embraced the idea of balancing. And this was the one place where he likened his balancing approach to an immediate scrutiny, which he explicitly mentioned. And all these other opinions were showing using the levels of scrutiny. But still, as one reads his opinion in Alvarez, one wonders, is anything other than immediate scrutiny? What's the test? He develops this a bit more in 2015 in Reed versus Town of Gilbert. Reed versus Town of Gilbert, I remember, involved a city in Arizona that had a restriction on public signs on public property. And it prohibited signs on public property that had almost 3 dozen exemptions. If the signs were political, they could be up throughout the election season, they could be quite large. But for other kinds of signs, they were restricted in size, it could be up only for a very short time. So in this case involved signs that were giving directions to worship services. They had to be very small for a very limited period of time. Justice Thomas wrote the opinion and said, this is a content-based restriction on speech. Whether the sign remain up for a long time, the sign can be large, depends on the content of the message. We strike it down. Justice Breyer, referring the judgment, which he very much disagreed with this approach. And he said, well, the court was opening a Pandora's box. And he articulated what his interest balancing approach would be. He through this language, and I think it's the most specific he had ever been in articulating what interest balancing would mean as opposed to levels of scrutiny. He said, strict scrutiny is, quote, just a rule of thumb. And I find that perplexing. I'm not sure what it means to say that a well-established test is a rule of thumb. But he says, I would use content discrimination as a supplement to basic analysis, which in most of the First Amendment cases, as with the religion issue, works harm to the First Amendment interest that is disproportionate in light of the regulatory objectives. Notice again this use of the language, proportionality. He said, answering this question requires examining the seriousness of the harm of speech, the importance of the countervailing objectives, the extent to which the speech will achieve those objectives, and the other less restricted ways of doing so. And I think this is, for the first time, giving guidance to lower courts in how to do the analysis. But the question that has to be asked is this preferable to the strict scrutiny that Justice Thomas was using for the 12 analogy? And most recently, just this year, in the city of Austin versus Vegan National Advertising, Justice Breyer repeated the proportionality analysis and balancing to be done. That involves an Austin, Texas ordinance that restricted digital signs on buildings. So a digital sign was allowed only if it related to the content of what was going on in the building, not was the advertisement or something else. And the Supreme Court, opinion by Justice Sotomayor, said this should be regarded as content neutral. Justice Breyer wrote again and said, here's the point of the distinction between content-based and content neutral. Again, his language is content-based is no more than rules of thumb. He says proportionality analysis is appropriate. Now, one could respond to everything I said and argue that the test that's used doesn't really matter. That whether you call it strict scrutiny or intermediate scrutiny, or term it proportionality, or use the criteria for read, ultimately the judges and justices will come to the same conclusion. I don't believe that, though. I think the level of scrutiny serve an important purpose in our legal system. They provide clear tests that courts can use and then apply to specific situations. And over time, certainly got a sense of what's compelling or important or legitimate interest. I don't want to overstate this. Obviously, there's enormous discretion within the levels of scrutiny, but I do think they provide a predictability in the law that just calling it balancing proportionality doesn't. Let me give two other examples of Justice Breyer's where I think his failure to follow the levels of scrutiny have undesirable consequences. One is with regard to a decision where he dissented. This is a case called Entertainment Merchants, Mr. Brown, a decade ago. It involved California law that made it a crime to sell or rent a violent video game to a minor under 18 without consent. Many states have adopted similar laws. Without exception, every court has struck down these laws. Almost all the states did so on vagueness grounds. Defining what's violent proved exclusive, say defining what's obscenity. The Supreme Court, 7-2, invalidated the California law. Justice Scalia wrote the opinion to the court. He said, this is a content-based restriction on speech. Violence is not a category of unprotected speech. Therefore, strict scrutiny is to be used, and common law violated strict scrutiny. Justice Breyer and Justice Thomas were the only dissenters. Justice Breyer gave deference to the state. Now, there's trouble with Justice Breyer's opinion doesn't ever deal with the vagueness about the state. But I also don't think he ever engaged with Justice Scalia's analysis of why this law was content-based and why it fails in scrutiny. The other case, more recent, where I would criticize Justice Breyer's approach, was from a year ago. Honey area school district, SPL. This is a case, I think, because of facts that got a lot of media attention. It involved a high school cheerleader, Randy Levy. She tried out with the varsity team. She was upset. She was again assigned to the junior varsity. She went on a social media platform and did a rant where she repeatedly used profanity and raised her little fingers. She then posted something else on social media without profanities. The cheerleading coach saw this and said it was conduct unbecoming a cheerleader and suspended her for a year. She and her parents sued. They won in the lower courts. And they won the Supreme Court in an 8-1 decision. Justice Breyer wrote the opinion of the court. Justice Breyer expressed concerns about schools punishing such speech in non-school hours, social media. Talking about generally, parents are responsible for the behavior of their children out of school. He talked about the dangers of letting schools punish students when they do 20 hours a day, 7 days a week. Talk about the First Amendment when it teach children the importance of speech and not punishing. He said, here there's no indication that the speech was active as well for the school activities. But imagine that you're a lower court judge, or a law clerk to a lower court judge, and you're dealing with a case that involves a school punishing a student for speech over social media. No matter how closely you read Justice Breyer's opinion, you're going to know who to test you about. I got the opportunity to talk to some judges who had to deal with cases involving student speech over social media last year. And then we have to find what's the test that Justice Breyer is articulating for them to use. Now, in many ways, I think Justice Breyer's opinion is a quintessential Breyer opinion. It has many important factors, but it gives some guidance to the local. I think a lot of what this conference is going to be about is assessing the legacy of Justice Breyer when it comes to the First Amendment. I think there are many areas of law where you have a lasting legacy. I'm going to do some of those areas. But I don't think that Justice Breyer did a lasting legacy with regard to the First Amendment. With regard to the religion clauses, I don't think it's articulated as they'll be followed, but it can be followed in the future. With regard to speech clauses, I don't think that his interest balancing or proportionality is likely to secure majority support in the years ahead. So maybe, to end where I began, Justice Breyer's most important legacy is that of being a truly decent man of the Supreme Court for almost 3 decades. Thank you so much. You guys have questions?
Does anyone have any questions? Breyer's jurisprudence and the critique of his proportionality analysis, Breyer draws in foreign international law. I'm wondering to what extent you see him drawing from his administrative law background and his where in administrative law where multi-factor tests and proportionality type analysis might work.
That's a great question. I think so. One of the things that is so many of the Breyer opinions is just what you say, multi-factor tests. I think totally outside the original about now, there's a case where about the necessary and proper clause of Comstock, where he has like 5 considerations. And again, I wonder, if I was the lower court judge, how would I apply those 5 considerations? Some point one way, some the other way. Of course, whenever there's multiple considerations, it's likely that some will point one way and some will point the other way. So it provides much less guidance than something like the levels of scrutiny. And I think it is important to recognize his background in administrative law. And I hadn't thought about the connection of that with, say, free speech jurisprudence. That's a great point. Oh, please.
Yeah, I'm curious what you think about Breyer's position in Sherlock versus Boston. I'm perplexed because, in one sense, very hard. Justice Kagan didn't know why he was in the Supreme Court, and so it seemed like it was a piece of fix. And yet, Breyer wrote again this long, perplexing test that it seems not going to be what will be in the future, rather Alito's concurrence maybe that. Can you explain how it is that he looks at these cases and yet draws a bigger issue than it should be?
It's another great example of what I was trying to talk about. For those who aren't familiar with this case that was decided this year, Sherlock City of Boston, there are 3 flagpoles in Boston. One of them, the city will regularly raise flags from private groups. And I think 284 times they've been requested by private groups to raise the flag. And 284 times they raised it. And Harold Sherlock came to them and said, I want you to raise a flag that's just across. And the city said, no, we can't do that because of the establishment clause. Sherlock sued. The lower courts in favor of Boston, the United States Court of Appeals for the First Circuit said that the flagpole is a place for government speech. The Supreme conflict saying free speech clause. First, when the government is creating more private speech or regulating private speech, and then you can use the free speech clause to challenge it. In this market, in a very simple case for the Supreme Court resolve and say, when the government 284 times gets pressed, it grants them 284 times. That's enough to indicate this is a forum for private speech, this isn't the government speaker. But you're quite right, that Justice Breyer then goes through many factors, and no one could distill it into anything like. You can remote it like test the lower words to use, and then the end says, following is government. When the government is created for private speech, you can't discriminate against religious speech. Interestingly, Justice Gorsuch writes in saying, the problem with these government clauses, Lemon versus Kurtzman, and we should overrule Lemon. And then, of course, just a couple of them. Sure, looking on May 2nd, on Monday, June 27th, Kennedy was Birmingham School, Justice Gorsuch, and we've already overruled Lemon versus Kurtzman. But I think Justice Breyer's opinion in Sherwood is a quintessential Breyer opinion because lots of factors and analysis, but unfortunately, not much guidance.
Thank you so much for answering everybody's questions. Let's give another round of applause to Dean.
Hello again, everyone. I would like to introduce our moderator of the first panel, Breyer, Andrea, our faculty advisor as well. Andrea joined the University of North Carolina Law Faculty in 2015 and serves as the Samuel Ash Distinguished Professor of Constitutional Law. Teaching and research interests include constitutional law, media law, civil procedure, national security, and torts. She's the author of numerous book chapters and articles on media law and First Amendment topics, including universities and speech, government secrecy and the press, public employee speech rights, and government speech. Professor Papandreou clerked for Associate Justice David H. Souter of the United States Supreme Court, Judge Douglas Ginsburg of the United States Court of Appeals for the D.C. Circuit, and Judge John G. Cole of the U.S. District Court for the Southern District of New York. She practiced law at Williams Connolly in D.C. and taught at Boston College Law School prior to joining us. We're so happy she's here, and she will take it from here.
I'm going to let panelists up here so we just pause for a moment. Or be with us in a moment. I speak. I am so excited that you all are here. Speakers we have invited some of my mentors, my role models, my idols, my great friends. So that's what a symposium is all about. Is to bring together people, and I've just been introducing everyone to everyone else, and we're having a grand time. I have been personally obsessed with Justice Breyer's jurisprudence, particularly after this maddening Mahanoy decision, and we'll talk more about that in the last panel. I did want to mention that for those of you who have more questions for Professor Jabrinsky, he is on the final panel of the day, and we will be talking about many of the themes that he raised in his. So I'm going to get started with our introductions for the media momentarily, but I'm starting with Enrique, our Mijo. Enrique joins us from just down the road at Elon Law School. He's also a fellow at Yale Law School Information Society Project and the Center for Information Technology and Public Life here at UNC. And he's a faculty fellow with the George Washington University Institute for Data, Democracy, and Politics. Prior to joining Elon, he was an appellate lawyer at Covington and Berlin, where he did litigation, media law, and First Amendment. I could say much more. I'm not going to read the entire bio. You have the program, so I'm just going to hit some high points. But thank you for coming. Enrique is one of my dear friends, and a dear friend who wants to talk about dear friends. Clay, these are my friends. Kate Howard is the President, Scholar of Mass Communication, and Director of the Marion B. Breyer First Amendment Project at the University of Florida. He holds a joint appointment as Professor of Law with the Levin College of Law, and he's authored or co-authored, including one forthcoming article with me, in 150 law journals related to freedom of expression.
It's 50 less than your prior speaker.
Our next speaker, Laura Dickinson. Laura, I forgot to ask you how to pronounce your chair. How do you pronounce your chair? Oswald Science Book Club. Okay, great. That's her research professor of law position at George Washington University, and her work focuses on national security, human rights, law, armed conflict, and foreign affairs privatization. I want to highlight some of Laura's work experience. First, Laura and I got to know each other clerking, where she was the law clerk for both Barry Blackman and Stephen Breyer. So we've known each other now for a long time. And she also served as special counsel to the General Counsel of the Department of Defense in 2016, and as a senior policy advisor to Harold Koh when he was Assistant Secretary of State for Democracy, Human Rights, and Labor at the U.S. Department of State. And finally, last but not least, another dear friend, Alex Tesis. He's the Raymond and Mary Simon Chair in Constitutional Law and a professor of law at Loyola University in Chicago. And he's a visiting professor of law at George Washington Law School. He is the general editor of the Cambridge Studies on Civil Rights and Civil Liberties and the Oxford Theoretical Foundation in Law. His most recent book is Free Speech and the Balance, Cambridge University Press, came out in 2020. So thank you, panelists, for joining. I think, are you going to kick us off?
Thank you all for coming. Before I get started, I just want to, since we're back together in person, I want to mark the passing last summer of Arnold Lilly, who was my First Amendment teacher. So they enrolled in me being able to do things like this talk. And he was also the founding faculty advisor of this journal. So Arnold was someone we have to thank for being able to get to. So this talk, the theme of this talk and the title maybe is Justice Breyer, First Amendment Progressivist. I'm going to talk about four things. The evolution of content discrimination doctrine over about 50 years. In particular, the evolution from a text-based test to a government purpose-based test. The way that the Supreme Court resolved that issue, in a case we heard about this morning in 2015, called Green versus Town Gilbert. Justice Breyer's objections to that case's favoring of text over purpose is evidence not just in that case, but in his First Amendment approach to cases generally. And then lastly, I'll try to give Justice Breyer a couple ways to feel better to the extent he gives. So, as Dean Chemerinsky mentioned, the content discrimination doctrine, more commonly called content neutrality doctrine, basically says that government can't treat speech differently based on the content of that speech. If the court finds that that's what happened, the speech gets strict scrutiny review. And this doctrine goes back almost exactly 50 years to a case called Chicago Police Department versus Mosley. And in unanimous opinion, Justice Marshall says that there's a picketing ordinance in Chicago that discriminates on the basis of content because it bars picketing in front of the school, but creates an exception for picketing that's based on labor dispute. So the way that this doctrine arose, at least formally, was it was concerned with statutory disfavor of content category of speech, right? And that because it's concerned with statutory text, with a facial inquiry, if the statute disfavors, that constitutes content discrimination, and the First Amendment is worried. But in practice, over the kind of intervening 45 or so years, after those lower courts start to consider government purpose and government motivation in applying content discrimination doctrine. And what this boils down to in the lower courts is a test that asks whether or not the government reference to statutory content distinction is based on, quote, express disagreement or disapproval of the content that's being disfavored. And this leads to lots of, at least in my view, speech-averse results. You have sexually explicit speech cases, court comes up with the much maligned secondary effects doctrine as a way to let statutes treat sexually explicit speech in a disfavored way, finds those laws to be content-based despite being content-neutral, despite being content-based. So the case, you have panhandling bans throughout the United States being upheld, or at least surviving, not being subjected to strict scrutiny because lower courts are saying, well, these ordinances don't ban panhandling because they disagree with the message of the panhandler. So what this test began to boil down to over the course of years is that when a court reviews a statute that makes a content distinction, the court then searches for evidence of discriminatory purpose or motive with respect to the reference. But what that actually means in application is confirmation of the absence of a discriminatory motive or discriminatory purpose with respect to the content. And the reason that the government was doing so many of these cases is because they're going to find a discriminatory motive on the part of the government to disfavor content because, well, for lots of reasons. One reason is that, as Judge Easterbrook famously said, the legislator is A, not an it. As Justice Black said, and a otherwise problematic protection case coming from Thompson, the legislator can always change its motivation. The court doesn't like it, right? And during or after judicial review, the legislation purpose changes to benign purpose, and that saves the statute. So again, the doctrinal rule here becomes if there's no evidence of discriminatory motive with respect to the statutory disfavoring of categorical content, then the government avoids strict scrutiny because that baseline of neutrality hasn't moved. And I say in one paper that an original sin here was calling the doctrine content neutrality, right? If you call it neutrality and the absence of any content animus, it rises to the level of applying it as a higher level scrutiny person. Government always wins because the court says. So along comes passive reply in this community church. Applied Read does not have a church building. Book of Matthew says that you don't need a building to have church. It makes it a lot harder to have church when you don't have a building. So Pastor Reed is putting up signs saying where his church is going to be. As each of us also said, the town of Arizona has a sign ordinance that says his type of sign advertises what it calls a temporary event. It can be up 12 hours before church, after church, so it's a fellowship from the church. Pastor Reed has to get to pull that on the sign. And then I circuit that says this is fine, right? Why is this fine? Because the version of content discrimination that I just described, there's no evidence that the town of Gilbert adopted this restriction because of its disagreement with the message on temporary event signs. The first problem. Pastor Reed files a cert petition, it's granted, and the Supreme Court reverses it. And the Reed test that the court adopts, that I'm thinking about Justice Thomas, is what I've called in the previous word a content discrimination two-step. So if the face of the statute refers to content, that statute is content-based. If the face of the statute does not refer to content, the statute still may be content-based if there's a content-based purpose behind that facially content-neutral statute. So unlike the test as it was evolving in the lower courts, purpose doing what doesn't see. So a content-based purpose can get strict scrutiny, but a content-neutral purpose can save you from strict scrutiny. And a lot of people are very bothered with this directive, and Justice Breyer is probably bothered by this. We heard a little bit about his opinion. I think you can read Justice Breyer's career at the Supreme Court in the speech area as a fight generally against what he perceives as an excessively negative theory of the First Amendment that assumes government distrust with respect to every First Amendment case, right? So every First Amendment case begins with a distrust of the government, and it didn't occur to me until 15 minutes ago when we were asked a question about maybe because of Justice Breyer, where he came from, right? The bureaucrat is more inclined to trust the legislature than the bureaucrats. Maybe that's where this is coming from, but this is evidence in lots of cases, right? In Turner Broadcasting in 1997, he takes the government's word about must-carry rules. He says, look, this is about promoting a diversity of sources. And Playboy in the year 2000, he says that Congress is not scrambling sexually oriented channels because of some moral judgment about the content of those channels, but because it's harmful to children. And Brown, as Steve Chemerinsky said in 2010, he says the relevant category for the First Amendment is not depictions of violence, but the relevant question for the First Amendment is harm to children, which California found that these games cause, right? And this approach, and Dean Renson talked about it, I think Faye and Alistair can talk about it, takes what Breyer calls countervailing government objectives directly into it. So when we see a statute that references content, we immediately are required to ask what countervailing government objectives are, not just in deciding to set the level of scrutiny, but in applying the First Amendment to that reference, right? So this is a test that obviously and expressly takes government purpose motivation into account when resolving content issues. So just to go back to read again, lots of consternation about the content discrimination test, how it's going to be applied, Justice Breyer is talking about the localization of the First Amendment. And as Justice Breyer is making this argument in subsequent cases, he has one point that is unassailably correct, right? Speech is everywhere, and content regulation of speech is everywhere. So he's talking in the cases about SEC disclosures, that's a content-based compelled speech, doing drug labeling requirements or content-based speech. I think this example is from Dean Post, so I'll give him a citation for this. If a public school teacher tells a student to write a paper about a great historical figure, that is content-based compelled speech. And then if a student writes that paper about Hitler, and the teacher gives that student an viewpoint discrimination, right? The entire commercial speech and for content-based. The first question is whether or not the speech is commercial. So Justice Breyer is again reiterating his concerns, reiterates them again in the city of Austin, which Dean Jurisprudence also referred to. I think that's his next to last major First Amendment speech case on the court. But I think Justice Breyer protests too much, and here's why. So this conception of Justice Breyer in the free speech area that takes purpose so into account, I think fails to take adequate account of what was the motivating concern of most of the case 50 years ago, and that is discretionary charging by the statute, right? So if a statute refers to content, and the court says there's no problem because that reference to content is not motivated by animals, the statute survives, there's nothing preventing a subsequent enforcer from coming along and applying that statute in a way against content that the enforcer of the statute disfavors. So I think this is a problem, right? Now, Justice Breyer is not obviously in favor of discrimination. What Justice Breyer says is we have ex post challenges to that statute, right? So if a sign enforcer comes along and cites the Muslim church for having unlawful on-premises sign, but doesn't cite the Christian church for having an on-premises sign, well, the Muslim church can come in and bring a First Amendment challenge after they're punished. But again, I think the motivating principle behind the content discrimination doctrine was intended to try to prevent that discretionary enforcement from happening. And then the second reason I'll put this why I think Justice Breyer should do better is that it would be quite easy for 5 of Justice Breyer's former colleagues to just say that this version of content discrimination doctrine, the facial two-step that only takes government purposes into account, just doesn't apply, right? It just doesn't apply to commercial speech. It doesn't apply to health and safety-based disclosures. In the robocall statute case in August 2020, Justice Kavanaugh was voting for himself, Congress, Leo, and Thomas. In the case expressly that existing First Amendment doctrine doesn't apply to the constitution of ordinary economic regulation of commercial activity. I think in the First Amendment area, especially this lower court judge, and even now Justice Kavanaugh has talked about the idea that if a government practices law get thought to present a First Amendment problem, then it should be a First Amendment problem. In the city of Austin case, Justice Alito said the content discrimination doctrine doesn't apply to commercial speech. Now, I understand that just moves the battlefield up to the battlefield. What is commercial speech, right? That comes up in the Barr case. It also comes under the Sorum case in 2011. But I think that's a better argument to have than the parade of horribles that Justice Breyer continues to bring out this content discrimination doctrine back to the ratio test and stop taking government purpose motivation into account. And this is just the last point. I think lower courts have actually been doing a really good job on this, right? Lower courts have said that of safety regulations, basically, discrimination. We can apply here in the Fourth Circuit. We have an example that very recently, a case called Breyer versus Morrissey. Judge Wilkinson writes an opinion who says that greed does not apply, and indeed it cannot apply to a statute that regulates the solicitation of medical devices and medicines. Statutes that, in Judge Wilkinson's words, go right at the heart of West Virginia's case now. So, I'll leave it there.
Terms of play, I should have mentioned, sorry, that we will have some time for questions at the end. So, and panelists, I'd love for you to ask each other questions if you think. So with that, Clay,
No, first let me say thank you to Rachel, the editors, the staff, the First Amendment Law Review for having me here today, and specifically the honor of being able to talk alongside a list of truly illustrious scholars. So, for example, when I first learned that Jeffrey Stone and Robin Post and Erwin Chemerinsky, all three of whom are current performing deans of some of the nation's top law schools, according to the former rankings of these problems, we're all going to be in the same room at the same time. I got to worry about that situation. What if something could happen? So, I thought maybe one of them should be located in a different room across campus, zoom in, or maybe all the way out in Hartford. Because as you all know as law students, you all rely on their treatises, their horn books, their case books, or their other scholarly books. So it's quite an honor. And for what it's worth, I just wanted to mention this briefly. So when I took my law review course back in 1991 in Sacramento, California, Dean Chemerinsky delivered 2 live lectures on constitutional law, and just as he did here today, he delivered them without a note, a question. I would say the only time I've ever seen him pull out a piece of paper was today, and he had a quote from that decision. So it was very impressive on that. I also wanted to add that my very first continuing legal education, which we all have to do after you pass the bar, was in 2 years ago in August of 1992 in Century City, California, in the Century Plaza Hotel. And Dean Post, who was at Berkeley at the time, was one of the speakers there. He spoke about IIED. He written about the Hustler versus Aldo case, and Alan Isaac was one of the attorneys who argued that case. He was there. And then finally, for Dean Stone, when I taught constitutional law 2, the back half of con law at Georgia, where I went to law school, I used his book. That was spring 2011. So I'm just really flattered to be among all of you today, plus the other panelists, but just by way of example. So what I'm going to talk about, and some of this will sound familiar because you've already heard it from somebody far better than me today, but repetition is the law of learning. So you're going to get another dose of it, and I'm going to drill into it a little bit more deeply. And I know Justice Breyer's preferred proportionality approach to scrutiny drive Professor Cobb and Gray here, shall we say, batty and bonkers. So I greatly appreciate her willingness to tolerate us talking about it today. So indeed, I'm going to talk about how Justice Breyer repeatedly attempted in his free speech jurisprudence to bridge First Amendment theories and values with First Amendment doctrine. So as Dean Post has written, quote, the function of doctrine is both to implement the objectives attributed by theory to the Constitution and to offer principal grounds of justification for a particular decision. And Justice Breyer, with his proportionality approach, attempted to find such harmony, I would argue, between theory and doctrine in free speech cases. In doing so, Justice Breyer rejected a rigid categorical approach to determining the appropriate level of scrutiny, as Dean Chemerinsky mentioned. Straight, intermediate, or some cases will be might consider to be rational basis, such as free speech in public high schools, the Hazelwood versus Kohlmeyer case, and also prisoners and inmates also to rational basis test, basically. And all of those marginally hinge on whether statute is either content-based or content-neutral. And as Dean Chemerinsky mentioned, categories and labels for Justice Breyer were just that. They were rules of thumb, not binding classifications. And it's not that he flatly rejected the use of strict scrutiny, the most rigorous form of judicial review. Indeed, he believed that strict scrutiny actually was appropriate before First Amendment values and interests might be toward by a statute. That's when it would come into play. He wrote that strict scrutiny is appropriate in instances of viewpoint-based discrimination, so he was more focused on that as a subset of content-based. When neutrality in a traditional public forum is threatened, and when poor political speech is impacted. But applying strict scrutiny simply because the statute is content-based was unnecessarily jeopardized the statute. That's what he argued, given his sledgehammer approach and really killing off most statutes. So, I think you read my paper about this one. So more pop culturally put, from the August era, Justice Breyer believes that the court should loosen up its categorical buttons. In this particular in my article, I do drop a footnote and include a link to the Pussycat Dolls song. So anyway, the court should loosen up its categorical buttons is what I'm arguing here. Prior proportionality approach focuses on a key question, and that is whether a law works harm to First Amendment interests that is disproportionate to furtherance of legitimate regulatory objectives. So again, what's the harm work to those First Amendment interests and values? Is it disproportionate to the interests that the statute serves? So First Amendment interests for Justice Breyer were really the same then as First Amendment values. So in IMP versus Brunetti in 2019, this is a trademark case. He wrote that the court should appeal more often and more directly to the values the First Amendment seeks to protect, in deciding how rigorously or how deferentially it should examine a statute. So why should the court do this? Justice Breyer wrote in one of his books that values are the constitutional analog of statutory purposes. That's where the values are like the statutory purpose. So this in turn means that when the court confronts issues involving free expression, Justice Breyer believes it should examine, and I quote, the expressive values that underlie the First Amendment's speech protection. Now, so to resolve the question of whether a statute works harm that is disproportionate to the values in question, he considers four variables, and Dean Chemerinsky already went over these: the seriousness, the harm. So we can try to, again, many factors, many parts of the test, but no clear rule. The seriousness of the harm of the speech, importance of the countervailing objectives that the legislature has adopted this law, the extent to which the law will actually achieve those objectives, and finally, whether there are less restrictive ways of achieving that. And indeed, as Dean Chemerinsky suggested, that does sound a lot like intermediate scrutiny in that approach. And in fact, in the Alvarez case, the Stolen Valor Act case, he analogized to intermediate scrutiny. So with that background in mind, what I want to focus on is how Justice Breyer then attempted to wed the two most venerable theories of the free speech tradition, namely the marketplace of ideas, and then a very democratic self-governance that he really referred to as active liberty, the title of one of his books. Justice Breyer often cited the marketplace of ideas in free speech cases. In his final year on the court, he wrote that the First Amendment helps to safeguard what Justice Holmes described as a marketplace of ideas. And in fact, all told, I could find 9 opinions where he directly references the marketplace of ideas in his decisions. But he seemingly valued the marketplace of ideas not necessarily for its ability to produce the truth production being one of the central goals of the marketplace of ideas, but rather more as a means of providing citizens with a structure for discussing ideas, for generating informed opinions and ideas on particular topics, and then in turn for transmitting those informed opinions to their elected representatives. And that in turn would influence public policy. So the marketplace of ideas served a different function, generally speaking, than rather producing truth or testing truth, but for generating informed opinion and then passing and transmitting that informed opinion along to elected representatives to enact, as Breyer said, the people's will is really what we're concerned about in a democratic society. So, in other words, the marketplace provides a robust and free marketplace of ideas, but it serves another constitutional value, and that value then is democratic self-governance. And this is where we're bridging those two theories, in which citizens then influence public opinion and in turn the law, and this is where active liberty comes in. So for Justice Breyer, any regulation that might harm active liberty merits close judicial review, while a regulation that might facilitate active liberty deserves more deferential review. So in short, active liberty, this is the title of the 2005 book by Justice Breyer, refers to the requisite level of participation and connection between people and their government that facilitates, as I mentioned earlier, translating the people's will into sound public policies. So thus, for Justice Breyer, the most rigorous level of scrutiny should be reserved for statutes that either harm the citizens' ability to freely receive and openly debate information and to express viewpoints that might influence public opinion, or with, again, rigorous review, when it would hinder the ability of people to transmit their thoughts to the representatives. So in brief, the process of forming public opinion and then the avenues of transmitting it were really central to Justice Breyer. So as I noted earlier, Justice Breyer would apply strict scrutiny in cases where laws suppress individuals from conveying viewpoints and when they disparately affect people in traditional public forums when they're attempting to speak. So it should be noted here that if there's one current scholar who may have influenced Justice Breyer's understanding and interpretation of free speech values, jurisprudence more than any others, it likely is Dean Post. For example, in Justice Breyer's 2017 opinion, in one opinion, he cited Dean Post's book, Democracy, Expertise, and Academic Freedom, to support Justice Breyer's assertion that when the government seeks to regulate, and this goes to a point that Enrique made, community activities of all kinds, it's often wiser not to distinguish speech from conduct. The notion that speech permeates almost everything. That was in the expression scared design case. This observation then allowed him, it gave him an entree in that particular case, to again try to argue that it's waste of time to try to untangle speech, again, against the categorical approach. And he said the court should simply ask whether or how the challenge statute, rule, or regulation affects an interest that the First Amendment protects. And in turn, in accord with democratic self-governance theory, he stressed the safeguarding the processes through which political discourse and public opinion is formed. Those are interests that are very close to the heart of the First Amendment. He repeats this in Barr versus American Association of Political Consultants, which Enrique mentioned. Again, citing Dean Post's democracy, expertise, and academic freedom. So in several of these cases, he goes off and he cites Dean Post, so it's clear that it's a major influence. So now to conclude, and I'll wrap up here, the question becomes what happens now to Justice Breyer's interests and values guided proportionality approach to scrutiny in First Amendment cases now that he's no longer the best. So what do we do now? What happens to this interest and value proportionality approach? Well, Justice Breyer announced in January 2022 that he retired from the Supreme Court. He stressed that the United States represents a democratic experiment. He made the same point several months later, talking at UVA's School of Law, a democratic experiment in our country. Now, his words harken back to another justice who recognized the experimental nature of our country's constitution and government. So slightly more than 1 century earlier, when Justice Oliver Wendell Holmes implanted a marketplace of ideas into First Amendment jurisprudence, he observed that placing faith in the free trade of ideas and the competition of the market constitutes the theory of our Constitution. And then, of course, he famously added, it is an experiment, as all life is an experiment. So as I explained earlier, Justice Breyer often invoked the marketplace of ideas theory that Justice Holmes then implanted into First Amendment jurisprudence. So perhaps then I would close with this. In the spirit of what Justice Holmes and in honor of Justice Breyer, he recently called the Great American Constitutional Experiment, time has arrived for the Supreme Court to test out in a purposeful manner a bribery approach to judicial scrutiny in First Amendment speech cases, even though it would drive Nietzsche and Rusty nuts. So here's how it might look in a test drive. Categories of classification would take not a back seat, at least a turn riding shotgun in the front passenger seat. And values of proportionality would take over the wheel in the driver's position. Second, those interests and values would steer the court down the road toward heightened scrutiny and review, where the mechanisms necessary for active liberty are jeopardized, and generally away from it when ordinary economic regulatory programs and commercial speech are at stake. Points he made in the Netflix case. Spotting a content-based law on the road ahead would not mandate making a hard right turn in the direction of strict scrutiny down a path toward probable unconstitutionality. It would instead be more akin to a flashing caution sign or a rule of thumb, urging the court to slow down, to keep its eyes wide open whether core expressive values the First Amendment interest are possibly jeopardized. And finally, of course, I'll close with this: if the experiment scrutiny determination were to crash, as if it were driven by Toonses, the driving cat on Saturday Night Live, the old categorical approach would be called back into service, perhaps with a little bit of values-based fine-tuning. And with that, I will stop.
Presentations, including a questionable citation to the scandals. I appreciate your comments and insights. I think it's a great segue for more of Dickinson's presentation that will focus our attention on democracy and the First Amendment.
Great, thank you so much, Rachel, and Larview and Dean. It was truly wonderful. So in this talk and paper, I'd like to explore some aspects of the relationship between the First Amendment and national security law, and using the lens of Justice Breyer's jurisprudence. And some aspects of national security law, the First Amendment's free speech clause, have been well studied. For example, the historical criminal prosecutions of subversives, criminal prosecutions of leakers, media, and so forth. But I want to focus on some aspects of national security law that are less often studied in the context of the First Amendment, the First Amendment's free speech discussion. And I think that free speech scholars should pay more attention to this. And these are two types of cases. First, where people claim that government surveillance is chilling their speech rights in the national security context. So lawyers, if they want to talk to their clients, journalists, they want to talk to their sources, and others. And in this case, it turns out that the standing doctrine has been used to make it much, much harder for people to assert their First Amendment rights in this context. Another example is the state secrets privilege. This is the idea that the government, when it asserts the privilege, can block certain information in litigation, and sometimes the litigation entirely, for national security reasons. And of course, every time the state secrets doctrine is invoked, it's preventing information from reaching the public arena. So if your vision of the First Amendment is part, implicates the idea that free speech is necessary for democratic self-governance, and of course, this is a theory so ably described by Clay, most closely associated with Alexander Michaeljohn, but also by many of others in this room. That's your theory, then having information sealed off from the public under overbroad assertion of the state secrets doctrine, or a very, very high bar for standing in national security cases, that has a significant impact on First Amendment values. So I think that those doctrines are not normally thought of in the First Amendment context. I think that they should be. And I think it's appropriate to look at these questions in this symposium related to Justice Breyer, because in the last 10 years or so, he's been involved in two cases that addressed these issues. Now, first of all, I just want to make clear, I'm going to say a little bit more about Justice Breyer's vision of the First Amendment and his embrace of the sort of Michaeljohnian self-governance rationale. And I think, for example, in the finance reform context, he's even cited this theory to argue for certain types of restrictions on making finance contributions because they can foster greater democratic discourse, even though they might seek to limit speech in some contexts. Now, the Supreme Court as a whole has pretty much rejected this approach in Citizens United and other cases, but Justice Breyer has at least actively pushed for this approach. And in the national security context, we can see this coming up in direct First Amendment cases as well, notably Holder versus Humanitarian Law Project, where the majority upheld the application of a statute that criminalizes material support to organizations designated as terrorist organizations. In that case, the majority upheld the application of the statute against a First Amendment challenge. Justice Breyer was in dissent. He concluded that the organizations subject to the statute were also, in addition to doing terrorist activities, performing speech-related and public participation-related functions, and that people who wanted to communicate with them their speech shouldn't be criminalized. And he observed that speech and association for political purposes is the kind of activity to which the First Amendment ordinarily offers the strongest protection. So with that, I'd like to turn to these two doctrines of standing and state secrets. And I think it's useful to view these two doctrines when they come up in the national security context through the lens of democratic discourse, access to information, self-governance, and so forth as a First Amendment theory. So first, starting with Clapper versus Amnesty International. This is a case where the number of litigants, including lawyers, journalists, human rights NGOs, who had clients at Guantanamo, they want to communicate with terrorists, and so forth. And they argued that amendments to the Foreign Intelligence Surveillance Act had made it much, much easier for the government to surveil and sweep in their communications with these individuals suspected of terrorism. And they argued that they were very concerned, and reasonably so, that their communications would be surveilled. And so they had to avoid the phone, some text, and travel internationally, and spend a lot of money doing so, to not be surveilled. So that was the claim. And the majority opinion, with Justice Breyer dissent, didn't reach the merits, didn't reach their First Amendment claims. But basically said they hadn't satisfied Article 3 standing injury requirement. And the majority's explanation, in an opinion written by Justice Alito, is, in my view, a positively complex analysis of why these plaintiffs couldn't satisfy injury. Because he said their injuries were insufficiently concrete. Well, what did he say? He said you can't prove the government is actually surveilling. Well, I mean, that's not surprising. It's strict surveillance. Second, he said that if they could show a risk government surveillance now, they couldn't show that the government was targeting their communications for surveillance, and they couldn't show that the government was going to be using this particular statutory authority. He also said it was mere speculation as to whether the Foreign Intelligence Surveillance Program would approve the surveillance. And finally, it was uncertain as to whether the government actually obtained their communications. So basically, the majority said that the harm had to be certainly intended. In other words, it couldn't just be objectively reasonably likely to occur. And obviously, it's going to be almost impossible to meet this standard and assert underlying First Amendment claims. So really, the majority standard is really tantamount to saying that you can't bring First Amendment claim in this context. Now, Justice Breyer said he didn't say anything about it, but he rejected this standing requirement as utterly too high. And he said, look, the harm to plaintiffs is not speculative. It's as likely to be, and I love this quotation, as are most future events that common sense, inference, and ordinary knowledge of human nature tell us. So we got a very broad expansion of the government's powers in this statute. I think that this is a really important example of how the standing doctrine and a narrow approach to it can really limit First Amendment claims and has really important First Amendment implications because it chills lawyers in the communications of clients, journalists in the communications of sources, NGOs and their advocacy, and the like. Now I'd like to turn to the state secrets doctrine. And people may be somewhat familiar with this doctrine. This is the idea that if someone is bringing litigation that touches on national security, concerns the government, come in and assert the privilege as to some of the information, because the government is saying, we harm national security of this information, right? So, by definition, this doctrine restricts the free flow of information. It restricts the courts, the public, the following the courts, and the public at large getting access to information. Now, some information really does need to be kept secret for national security reasons. I am certainly not suggesting the doctrine should be abolished. What I am saying is that it has First Amendment implications, right? Because an overbroad application really limit the free flow of ideas that are necessary for democratic state. Now, the Supreme Court faced a really important and troubling state secrets case last term, United States versus Breyer. This is a case where we have a detainee, again in Guantanamo, who was captured in Pakistan, and then the CIA moved him around before they brought him to Guantanamo. And while they moved him around, the government tortured him by using enhanced interrogation techniques like waterboarding. This is something that the US government has, in fact, acknowledged. So he wants to bring a claim in Poland because he claims he's detained in Poland. So he invoked the procedure from the Polish court's openness, went all the way up to the European Court of Human Rights, which concluded that, yes, he was detained in Poland and was tortured. And so the Polish authorities had to reopen the criminal investigation. And then this case that I'm talking about arises because FIDA wants to get information from US contractors who were involved in designing the torture program related to this torture in Poland. And in the context of that, it would be acknowledged that the detention took place in Poland. And the government has never officially acknowledged that, even though it is a matter of public record, the European Court of Human Rights. So the government comes in and asserts the state secrets privilege. So that's the scenario. And the Supreme Court basically sided with the government in a very fractured 7-2 opinion. And Justice Breyer writes majority as to some aspects and plurality as to some aspects. And he says that even though the information was already public domain, the official governmental confirmation that the detention site was in Poland, that's tantamount to new information. And official acknowledgement of that coming out of the litigation would harm national security, would harm the government's ability to have relationships with other intelligence services, Poland, other countries as well. So he deferred to the government on this state secrets point. But he did at least maintain a role for it to do it. Unlike others in the majority, Alito and Thomas Alito on one hand, and Kavanaugh Barrett on another opinion, both sets of those pairs, both of them had a much more deferential approach to development. So Breyer put an approach that was less deferential to government in general, but in this case, setting state secrets doctrine should block the information going Poland and indeed the whole information should be blocked. Now, in an interesting alignment, Justice Gorsuch wrote a pretty stinging dissent, and he was joined by Justice Sotomayor. He didn't cite the democratic self-governance rationale, though. It was mostly a separation of powers argument, an idea that the courts have to play an important checking role. So the president and the executive branch don't become like a king, and this is essential for the law. I think that a democratic self-governance rationale here, rooted in First Amendment theory, would be appropriate to argue on behalf of the more narrow reading of the state secrets privilege. So in sum, I think these doctrines, which are what I would call First Amendment adjacent in the arena where national security law intersects with the First Amendment, I think that these doctrines bear attention from First Amendment scholars.
so much for our final speaker, Alex. Take it away.
Thank you so much. I'm very grateful to be here. Thank you so much, Breyer, for his leadership in the First Amendment law review, and General Rachel as well for all you've done that has brought us here. To me, all of these rights are really special. I mean, I think I often am drawn to a song that probably very few of you will remember. It's All Too Beautiful from Small Faces, or Integral Park it was called. To me, that's the way all of life is. It's one of the particularly settings where we share ideas, especially the way from the Soviet Union to be open and expressive about our differences is really phenomenal. And as you hear, my views is different than the one that was expressed by Erwin. Let's see if I can at least get some sort of thought for the possibility of Breyer's approach and where it might be at. In recent years, some of the muscular opinions by the Supreme Court have applied categorical reasoning in First Amendment jurisprudence. Reliance on formalism has empowered the court to rein in state legislators' efforts to protect consumer privacy against corporate efforts to harvest unlimited amounts of personal information. The Roberts Court jurisprudence has adopted strict construction of the First Amendment that makes up in activism what it lacks for nuance. The dominant perspective that has emerged among justices requires courts to exercise the most stringent judicial review for regulations on speakers' articulation of topics and perspectives. Without adequate differentiating between various forms of speech, the majority has adopted a version of the First Amendment that protects corporate dominance, commercial marketplace of ideas, while giving short shrift in, for example, Sorrell versus IMS Health, to state initiatives to safeguard personal privacy. While the libertarian strand of thought of the court has steadily augmented judicial power, Justice Breyer repeatedly voiced an approach more transparent and circumspect. He envisioned a First Amendment jurisprudence as a realm of requiring contextual analysis rather than a field in which the level of judicial stringency threatens to undermine legislative efforts to strengthen personal and collective interests in self-government, health decisions, and commercial communications. Breyer preferred a perspective on the free speech doctrine that rejected automatic reliance on strict scrutiny as a knee-jerk reaction to content-based category. He preferred a more contextual rigor he used in judicial analysis. Breyer's perspective has drawn much skepticism about the uncertainty of how this suggested balancing work and practice. There's something to that, for sure. Scholars like Professor Thickemeyer and Alan Brownstein nevertheless go too far in calling Breyer's approach free-form balance. Thickemeyer and Brownstein leave that categorization undefined. A closer look would find the approach analogous, although not identical to proportionality as it is reviewed in the European Court of Human Rights, in democracies like Germany, Estonia, Canada, New Zealand, Israel, South Africa, and Switzerland. Breyer's formulation is taken seriously, would rely on judicial reasoning to evaluate the benefits and potential alternatives in circumstances where the statute's work speech-related harm is proportionate to the benefit that statute seeks to provide. Professor Mickey Jackson's assessment of Breyer is comparativist. She draws attention of the coincidence between Breyer's reliance on weighing free speech against countervailing government concerns to approaches in Canada and elsewhere, and also as well in Europe. Breyer recognized the value of studying foreign opinions, but he also argued that the First Amendment must be understood on its own constitutional terms. My essay for the Symposium argues that Breyer's balancing approach to free speech can help explain why certain additional government regulations are contrary and viewpoint-based, but receive no more than rational basis scrutiny in areas like healthcare, intellectual property, security markets, professional regulations, and consumer law. This morning, I particularly want to draw attention to how Justice Breyer's proportionality analysis can provide insights into a current bipartisan bill that proposes to create general privacy protection quite similar to those currently enforced throughout the European Union. Any digital privacy law that would limit a company's access and retention to personal data would likely fare better under proportionality scrutiny that Breyer has proposed than does under the court's current vision approach. His analytical contribution would be most helpful at a time when the court seems keen on moving away from such Hudson's intermediate scrutiny test to something more rigorous. Privacy regulations of social media companies under Breyer's approach can be reviewed to determine the speaker's interest in the data, countervailing government, consumer policies, the fit between the law and intended legitimacy ends, and relevant alternatives to regulation. Given the commercial magnitude of the secretive corporate sales and barter in data, I argued in a recent argument that Congress should rely on the Commerce Clause authority to pass comprehensive privacy legislation. Indeed, as of this September, such a bill has actually been proposed in Congress, a bipartisan bill called the American Data Privacy and Protection Act. In passing the new law would mark a sharp shift away from a current patchwork of federal privacy regulations as well as laws of the court. ADPA is the most promising development in American privacy law in decades, but it would be tested by the court's free speech formalism and probably has a little chance of survival under that interpretation. The bill has several features that overlap the European Union's general data protection regulation, which is very strong protection on privacy in countries that are deeply committed to democratic free speech. The ADPA would require data controllers and service providers and large data holders to dispose of recovered data that is required to be deleted by law or is no longer necessary for the purpose of which the data was collected, processed, or transferred, unless the individual has provided affirmative express consent to such retention. Such a provision is likely to draw a formalistic response from the court. Its likelihood of surviving strict scrutiny is very small, whereas the proportionality approach would give greater deference to state-sponsored consumer protection. The pending law would require covered entities and individuals to be significantly more open with consumers on data they retain and then sell. The new law would add a dose of proportionality, weighing the interests of property against the commercial interests of speech at a time when virtually unlimited corporate data collection, retention, and transaction threatens to maintain data on all sorts of privacy information, all sorts of stupid mistakes we made as teenagers forever. The ADPA would create an opt-in regime undoing the current opt-out norm in the United States. Social media companies would be required to provide consumer opportunity to affirmatively express the content. There's an exception for affirmatively expressive content, and we talk about what that means Q&A. Moreover, in an effort to end social media company practices of obfuscating privacy notices under the pending bill, data collection entities and third-party collecting entities would be required to clearly and conspicuously provide consumers with notice and information about how they retain and sell digital information. This provision can be challenged on compelling speech grounds. On the other hand, proportionality would require the judiciary not be dismissive, but to weigh speech concerns with those of individual privacy. Both the U.S. and European legislative initiatives allow companies to control personal data and to collect it only for specified, explicit, and legitimate purposes, providing the sort of transparency that Breyer also suggested. The ADPA and the GDPR requires the internet intermediaries to erase personal data on the data subject's formal request, thereby helping to avoid such misuse of information as Cambridge Analytica in data in 2016. And this is a fact that presumably Cambridge Analytica didn't have to respond to under strict scrutiny and didn't have any challenge even, where 87 million users data was taken. And the only reason we know about it, the only one is one whistleblower came forward. How many such instances are going on continuously throughout the United States and the world is beyond anything we can consider. Certainly it's got to be in the billions. Facebook, at least at one point, had a membership of at least 1 billion. The pending bill's coverage includes a wide range of categories and personal information. If passed into law, it would perhaps fare well under Breyer's balancing formula while likely failing under the court's libertarianism. Breyer's balancing method would look quite different than an absolute sounding review that the court had adopted in Sorrell versus IMS Health and Citizens United, both of which hint at a future where the marketplace of ideas is further skewed by corporate opportunism. Justice Breyer's contextual approach is more nuanced than the currently accepted categorical use of strict scrutiny to strike restrictions based on their simple fact of content. The court's unwillingness to seriously engage with regulatory purposes is unfortunate because it diminishes the public's understanding of why certain forms of viewpoint discrimination are not part by law, such as those prohibiting harassment in the workplace. It's a particular view, and I can give you all sorts of examples that would be unnecessary what would be prohibited as a form of viewpoint. You look really good on it. And at the publicly, and as well as things at publicly funded institutions. Furthermore, the majority's approach renders remote the possibility of meaningful privacy protections. Without the robust balancing of speech and privacy, both critically important for human dignity, our sense of private identity will remain underprotected in the digital marketplace. We increasingly live in a world where efforts like ADPPA are likely to splatter on the wall of content absolutism. Breyer's proportionality makes clear that commercialization of speech does not give rise to the same concern that would orthodoxy or censorship of philosophy, science, history, sociology, religion, or art. His methodology recognizes that law is content rich in matters like antitrust law, copyright protection, fraud, education, and pharmaceutical warrants. Neither of any of these historical categories are of the type that are referred to in the United States v. Stevens, so the court can't simply say that these are historical categories that have not been protected because they don't apply in those cases. There's nothing there about securities regulation and other intellectual property. Rather, their legitimacy can only be explained through a form of multifactorial, contextual test, as the one suggested by Justice Breyer. Otherwise, any comprehensive privacy protection, be it EPA or some other, is fixing or running with the highest level of scrutiny that likely will render it still.
Thank you, Alex. I want to make sure you all know we welcome your questions. I have a few to get us started. Alex, my first question is for you. First of all, I really appreciate you representing a diverse viewpoint. Defending Breyer's approach, we certainly want that. And we will also, I know Professor Post will be a staunch defender as well, given that he's inspired Breyer very much this theory. I think I remember reading in the Fuller paper that you circulated to the panelists that there might be other things that we might layer into Breyer's proportionality analysis. Like what sorts of things might you, if this analysis were to take hold and take root, what are there other things you'd like to see Breyer include?
Well, I really appreciate that. Thanks so much for the room. I don't know if I'd say that I wanted to include other things. The papers really going to be about the richness of his approach to proportionality relative to the European approach, where it functions well without the sort of test, the four-part test that others have mentioned. Where I think his proportionality approach must be altered is to become a realist as to what the court is doing with text, history, and tradition. In other words, his text will fail, will not be adopted by the court unless it somehow also incorporates matters of what are the traditional government functions, for example, and what are the core principles behind the protection of free speech. He spoke about that as articulating values of philosophical thought, theoretical thought, and so on. But I think to be a realist, we have to include those things, those types of concerns that the court has gone more to, which are history, text, and tradition. Whether we agree with those or not, it's simply unrealistic. This test would be upheld unless it has some facets of those concerns.
And Erwin in his remarks talked about in the religion pieces in particular, where Breyer talked about the longstanding nature of, say, the monument in the Gordon piece, and that playing a role in Erwin suggested that was baffling, exactly what that rule is. But I wonder, is that perhaps open the door to looking at history and religion in a way that would be consistent with Breyer's?
Yeah, that's a great question. I too agree it's completely bad that way, because it goes completely against the establishment law. I would say that the approach has to be one that's true to history and tradition, which is what Jefferson's separation between church and state. And that's the true historical approach, not the one the court has adopted, where it pretends like the Brooklyn Cross in the American Legion case has no historical basis with religion. Clearly, the cross is quintessential to Christianity as well as the creche. So those are cases where it has applied history, but it has completely obfuscated the truth about history with what I would call is a form of activism that uses the terms of history, uses various forms of judicial scrutiny as forms of really acting in a conclusive way without really the depth of analysis that Breyer has called for, which clearly would say that those religious symbols historically are religious rather than based on what you said, 1 year, 20 years, or 100 years, whatever they cross, whatever fiction that crosses down, right? I mean, there's a portion in that opinion, the Department of School cross case where says that the cross is connected to all men who died in arms in World War I. Well, let's see you put up a cross on a Jewish or a Muslim soldier's grave. Let's see whether the family thinks it represents all soldiers or only some.
Clay, can you pick up on Alex's suggestion that to be realistic, the Breyer approach would have to embrace history and tradition?
Yeah, sure. So, I mean, if I could go back to the Second Amendment case, the Bruin case, which I think was mentioned earlier today too, where the court clearly adopted a text, history, and tradition approach. And I think the Chemerinsky in New York, the Supreme Court review for PLI said it was the most originalistic opinion we've ever seen issued in any case. I think the question is really, are we going to go down that in First Amendment jurisprudence? And then to tie this back to Breyer, the case, Breyer has a dissenting opinion in Bruin, because Justice Thomas, in his majority opinion, said this is how we actually analyze, protect free speech cases, protect history and tradition. And Breyer go back in that dissent, no, it's not. We have standards of scrutiny and we balance influence in that approach. So, I mean, I think that's an important point that Breyer at least pushes back against, this text, history, tradition approach in the First Amendment context, because Thomas clearly said that's how we protect First Amendment rights. And yes, when we carve out unprotected categories of speech, like Stevens' case, we ask, is there a long history tradition of this particular speech being banned or barred, even if the Supreme Court has not heard it? And yes, as we've talked about in other contexts, in the history and logic test for gaining access to public proceedings, you focus on that. But not in everything else. And I'll end here while we get off this whole issue. So the Fifth Circuit's opinion by Judge Oldham in the Net Choice case, who really embraces the text history tradition approach. He goes over Blackstone, and he talks about prior restraints. So it's really something that might be coming down the road.
Yeah, we'll see. Enrique.
I will call the answer adjacent to your question, but that's okay.
Enrique, it seems pretty clear that Breyer has an interest in promoting self-governance as when we think about primary purposes of the First Amendment having informed society. And Clay in his remarks talked about how Breyer has also cited the marketplace of ideas theory, at least at 9 times. And in one case, the one I'm obsessed with now, he also mentions the marketplace of ideas. And I'm just wondering, Enrique, do you see the marketplace of ideas as playing a central role in the way Breyer looks at the First Amendment? And if so, what does he mean by that? Because I'm not sure he means what everyone else means by it.
Well, I think how you feel about Justice Breyer in free speech cases, it tracks pretty well in kind of the first years. You conceive yourself as being right. You kind of draw the continuum. I'm not sure if it's a continuum, but if you're a Michael-Jonian Democrat who just pushed posted a million, or a Justice Kennedy self-autonomy person, that's pretty, where you place on that is pretty much going to decide where you sit with respect to Breyer. I do think it's notable that we talk about the theories that Justice Breyer talks about. He does not seem to talk about it at all. I guess the dispute is made, but obviously I think the reason for that is because his approach is very much a high value versus low value speech approach, right? And if you have decision makers deciding what is high value or low value speech, that is in direct conflict with self-autonomy rationale, because it's actually an offense to the speaker's autonomy or the decider to decide whether or not their speech is high value or low value. Autonomy theorists barred someone to a person. I get into speech. So I think the theories that Breyer points to, I think it's pretty clear indication that it's important what he thinks is not as important.
Well, I don't know if you want to weigh in on that marketplace of ideas. Right? And this job, yes, because when you think about the marketplace of ideas, for some people it means we let all speech flower and blossom and let truth rise to the surface. But I think with Breyer, it's a slightly different idea. He's using the marketplace as a vehicle. I'm sure I'm guessing Professor Post might elaborate a little bit more on how discipline should work. I know you've written about it recently on how the marketplace isn't necessarily required. The First Amendment isn't required every single voice to be heard.
And he's willing to regulate that market. Finance the context, equalize which kind of fall into the same.
We've got Postian, we've got Pistian, we've got. I like it.
While we wait, I don't think that's questions, students. You are very lucky. And I know many of you are in First Amendment, and you have an exam coming up. So, if you don't mind, I really love how you bring our attention to the important documents of the First Amendment. I just wonder if you thought about maybe the state action monitor should also be considered. I don't know that that's the main focus right now in the current social media regulation pieces, but it certainly has been in scholarly literature, some discussion. Or have you thought about that?
I haven't thought that much about it in this national security context.
Yes. Well,
but in general, obviously there's good literature on it, but that makes sense.
Breyer, I know he's weighed in on the state action doctrine.
Yeah, look at that. But I mean, I do think that this national security realm, the Zubair case is so funny because it's a funny little case because a lot of the information is already public. So from a democratic discourse point of view, a lot of this information is already there. So the harm from a democratic discourse point of view, the harm of the majority is not so terrible. Although, I wish that one of the justices had sort of thought about or spoken about the implications of that for the overbroad application of the state secrets doctrine. And I think Breyer I actually just think he was trying to cobble together a majority that would be less deferential to government than some of the others in the I think he was doing that in a lot of cases there towards the end. So I read that case that way as well.
I was just curious about, since we never did a question, and ask you a question. Where do you see student speech cases for the
Mr. Jaworski already said what I would say, which is just no real guidance to the lower courts. I mean, in one way, I think the Mattingly case, I'm so glad you gave me a platform to spout my nonsense. So the Mattingly case is a beautiful opinion in some ways because it does highlight the value. There's some core values, and there's some soaring language in there about the importance of the marketplace of ideas and the importance of public education in preparing students to participate in a democracy. And I just think that's just beautiful. Where it falls so short is that it just fails to give any guidance in a way, in an area where it's probably crucially important to provide this very guidance, particularly if you think about the power differential between students and the school administrators, where most of these cases do not end up being litigated, and most of these students do not have lawyers or ready, ACL, you can't take every case that comes, and maybe they shouldn't take every case that comes, but if you don't have clear guidance for the school administrators, at the very least, who by and large are not attorneys, and they don't have attorneys on speed dial necessarily for every single daily infraction that might occur, that to me is very troubling. And the fact that the court has had students speech case for many years, more so than the prior case. 2007, the court has not indicated an appetite for taking these cases here. Perhaps that would change. I think one thing I also think about Breyer's approach to the First Amendment became more not just in that way, but in broader cases. If you saw that proportionality approach develop in a common law fashion over time, it would perhaps then give more guidance, right? Because you'd see more decisions that would help people predict what the next decision might hold. But I think the real problem with for me, the Mattingly case is not just that there's no rule, but there's no rule in an area that really cries out for guidance. So I'm off my soapbox. Please step on up to yours.
Whether you are Professor Andre, but I think I should agree all that might settle those. We're talking about Justice Breyer's legacy, expression. I wonder what hurts will live on most, and will it be any parts that stick around the majority of these? Will there be particular tests or emphases or values that live on in dissenting opinions? So what feel perhaps in different areas where you can focus on? Do you all see Justice Breyer having a legacy that continues beyond his time on the court?
I think this will probably come up in the last panel of the day, but I think Justice Kagan is perfectly copacetic with a lot of the opinions that I talked about, that Justice Breyer wrote about, where the first question is really, in all of these speech cases, is what is the First Amendment for, right? And I think she is going to carry on the flag of being forceful with respect to, we have to first ask the question, what is the First Amendment for? It is not to invalidate laws that we don't like. It is to do things like promote democratic discourse in the marketplace of ideas, or allow judges and justices to think about things like high value and low value speech. What's the actual burden that this law imposes, and the type of speech that is burdened by this law. So I think she's absolutely going to carry on that tradition. I think Justice Sotomayor is a little bit more ambivalent on these questions. I mean, we had a lot of 7-2 free speech opinions, whereas I said Kagan and Breyer are perfectly in line. And whether or not future justices are willing to join in that.
Oh, actually, I agree with that. That's Dean Chemerinsky mentioned Justice Kate in the Janus decision about the lockerization of the First Amendment and her weaponization of the First Amendment. That's what she was really saying. Speech is everywhere. It's the same type of notion. As Breyer would call it, ordinary workaday social and economic regulation doesn't justify the strict scrutiny because the First Amendment interests and values are not really harmed. So I think you're right, Kagan's definitely the one taking the charge.
Alice or Laura, if you know it.
I would just say, in the national security context, I think when free speech issues come up directly or in the background, his pragmatism and his understanding of government needs sort of runs up against his concerns about protecting individual rights. But in the speech context, it's protecting those rights from a sort of democratic participation type rationale. I think that's illustrated by Holder versus Humanitarian Law Project quite profoundly, right, where he really latches on to that theory quite explicitly. And to a lesser degree, Clapper doesn't explicitly acknowledge it, or I think that's in the background.
I don't want to take up much time. I think insofar as there's the effect of Breyer in First Amendment and free speech jurisprudence, it'll be as a counter voice. And maybe it's not a fair analogy, but in the same way that Justice Harlan serves as a counter voice in Plessy Ferguson. If anything, it will influence European law. I hope it would, because European law is a free-form balancing test, whereas I think Breyer does create steps for analysis that, of course, they create uncertainty, but so too do the current tests for scrutiny, which can
Well, thanks for that great question, and we will be exploring that very question more in the three today. Next question, please.
Hi, thank you all so much for being here. I am Professor Marshall's First Amendment class, and
they don't know the answer to the exam.
obviously, in our class, we're looking at a lot of the subjects pretty much time, always getting into individual justices' opinions, and so I think that this is really interesting that we're really drilling into particular justice degree on this. And Professor Dickinson mentioned campaign finance jurisprudence, which I found to be particularly interesting, especially the dissenting opinions generally. At least in my mind, had a more realist approach to speech when it came to that area of law. And I was just wondering if you could elaborate a little on what Justice Breyer's approach, how that versus other justices of the Supreme Court, how that has affected his approach to finance law.
Well, we were talking about the level of scrutiny, it's kind of adjacent a little bit, the level of scrutiny. In terms of that active liberty principle, that any regulation that would enhance this marketplace of ideas where people could participate more and convey their viewpoints, if we're going to regulate campaign contributions or expenditures in a way that would allow more people to participate, you would less or more deferentially give review to that than rather than applying, I think, a strict scrutiny. I mean, there's a big picture principle. If active liberty is what he's really talking about in the marketplace of ideas, is they're not necessarily producing truth, but to allow people to participate. And you go in and you step into that marketplace to make it less skewed in one direction, and to enhance the ability of people to have access to it and participate, then he would be more deferential to that.
I would just say, yeah, he speaks about it through the case, but also in his book, Active Liberty, where it explicitly sort of embraces this idea that one of the core values of the First Amendment speech law is protecting is this to have democratic self-governance, that would allow for a rationale for limiting some speakers for the sake of the speech rights of the collective in a sense. And this, I mean, I associate this view with an open fist, who sort of has a, and Caslin state as well. I think it's that reflected very clear, and he explicitly talks about it in fact.
I've taken one of Professor Marsh's exams. I'm not going to give you any tips, because I don't want to do that. I'm a good one. Be ready. How you feel about these unverifiable premises, right? I mean, Justice Breyer would say, if you have $10, I have $1,000. My $10,000. If the limit is 1,000, and I give more than 1,000, that reduces the volume of your $10, right? And the conservative justices don't believe that, right? They just don't think there's any relation between how much I can give and therefore can say, and they just don't think that affects your ability to say the volume that you get to say in any meaningful way. I mean, Justice Breyer does believe that, right? He says the reason that we limit contributions is because if we don't, then the people who can give less, the person who can give more, is going to get cut out. And that's just you either approach the First Amendment in that way, or you don't. That's really the final thing about campaign finance.
Thank you for that question. We have time for at least one more, depending on what the question is.
Sure. Hopefully it'll be quick. First of all, thank you guys so much for coming. Thank you for abiding by the time cards and the lesson for the panelists and how it's a great example. My questions are
I didn't see the time.
specifically, my questions are for Professor today. I was really moved by our proportionality test is more adaptable to the needs regarding data privacy, social media, surveillance. But then I was also really intrigued by, for its necessity to survive, there has to be some sort of incorporation of text, history, and tradition. And to me, those sort of seem at odds because we haven't had social media or certain surveillance issues to the extent that we have today, previously in history and text. So I'm curious about how you kind of reconcile the adaptability and the applicability of functionality in those sort of issues, but also how do we mean today in historical landscape where expression seems to be a novel issue.
Well, one thing would be if the court were actually honest about history and tradition and text, which I think is completely disenchanted. And I think a lot of times these categories, tests, various methods of scrutiny are really ends-based tests. They have some conclusion, oftentimes it follows some political thought that's on the bench. It looks like it's a rigorous test courts can use, but in reality, it's very detrimental to history and tradition. Like the examples I gave about the cross or bringing in the Ten Commandments and sticking them in a government setting, the concept that corporations can fund political campaigns in the same degree as natural people are not historically grounded. So there's historically, just as, in the second case, Justice Thomas is not historically grounded. It uses history that doesn't really look at what the history of the Second Amendment is concerning militias. So one thing would be true honesty and transparency, which I think what Breyer is really calling for in these proportionality analysis, which would allow courts to review a national opinion as well in people to review it. Once again, very good testing was, where could it be even? One way is by using the approaches. Otherwise, there is no method to use. We have no chance of survival with at least 6 members of the court. Another one is to make his approach deeper if it's active liberty. That active liberty has to be something about our intrinsic humanity, which goes beyond democratic speech and goes also to self-conception, dignity, as well as the marketplace of ideas and the transmission of ideas. So I think that we have to be more honest about what free speech is, which is certainly beyond the historical realm of what the text of the Constitution really says. Otherwise, we take tax. If we just take tax, then the First Amendment only limits Congress's ability to censor. We must go beyond that. Sure, the president can't say to censorship for all of the time of war, right? And then if you look at history and tradition, I think then we were stuck with Leonard Kennedy's conclusion that prior restraints are just about all the First Amendment's do. And so, whereas history and tradition have their role, I don't think that they can be or should be the final determinant in judicial opinions about the First Amendment.
And I'll just say, Justice Breyer has embraced the idea of the whole constitution of the whole democracy, and so he is not. He sees the Constitution as evolving, it has to be workable. I think that's very different from the dominant view on corporate, and where everyone's an originalist now, right? But he's not, and I think he's looking for a workable, pragmatic way of the Constitution.
Thanks for your great question. I suspect we will also take up that topic at panel 3. We are now time. We're ready for lunch, so I'm going to call it. I'm sorry about that. For that last question, please join me in thanking these outstanding.
As Andrea said, we'll take a break for lunch. We'll be back here at 12:15 for our second panel. But in the meantime, if anybody else has any great questions for any of our panelists, feel free to speak them during the lunch break.
Hello, everybody. Panel 2 is titled Breyer and the Religion Clauses. It'll be moderated by Professor Eric Muller. Muller joined the University of North Carolina Law faculty in 1998 and serves as the Dan K. Moore Distinguished Professor in Jurisprudence and Ethics. He's one of the leading scholars of the removal and imprisonment of Japanese Americans in World War II and has published extensively in the field for more than 2 decades. He has also published in the areas of constitutional criminal procedure, the law of slavery, and the Nazi legal system. Muller clerked for Judge H. V. Sarakin of the United States District Court for the District of New Jersey. He worked briefly for a litigation firm in New York City and then served as an assistant U.S. attorney in the District of New Jersey before entering academia as an assistant professor at the University of Wyoming College of Law. At UNC, Muller served as the law school's associate dean for faculty development and as director for the Center for Faculty Excellence, the faculty development center serving the entire university. I was fortunate enough to have Professor Muller for common law side of your university. Without further ado, greetings.
It's going to be me saying hello, welcome, and being here. This is a great panel, and introduce to these fun folks to get them out of the way. And that's my so it is a pleasure to be here for this panel on the religion clauses and justice Breyer. Part of the reason I want to get out of the way is that we have an all-star here. And so we want to emphasize that I'm going to can't use them all at once at the beginning in order to speak. I'm just going to speak. So the first one is to speak to my is a professor at Notre Dame Law School, leading authority on questions and debates about the role of religious believers and beliefs in politics and in society. He's the founding director of Notre Dame Law School's program on church, state, and society. He clerked for Chief Justice William Rehnquist, as well as for Judge Richard Arnold of the 8th Circuit, and had a career in practice before academia at the Washington firm of Miller, Cassidy, Rosen, and Fluent. Next in order of presentation will be my good colleague, Bill Marshall. I asked Bill what he wanted me to say by way of introduction, and he said, tell them that I teach at UNC Law School. But I'm going to define Bill's instructions and tell you a little bit more about him. He's been with us in Carolina since 2001. He is the William R. Keenan Jr. Distinguished Professor of Law. He has published vastly and extensively, including at Harvard, Law Review, Yale Law Journal, the Supreme Court Review, University of Chicago Law Review, and many others. He also has a distinguished career outside of academia. He was Deputy Counsel to the President and Deputy Assistant to the President during the Clinton administration, and also served as the Solicitor General for the state of Ohio. Next up will be at the end of our table here will be Russell Robinson, who is a professor at UC Berkeley School of Law. He came there after a stint at UCLA. He clerked on the Supreme Court for the Justice. She's largely forgotten now, but his name was Stephen Breyer. Also worked for the U.S. Department of Justice Office of the DOJ's Office of Legal Counsel, as well as for the firm of Aiken Gump, Strauerhouse and Feld in Los Angeles. He's an expert on a number of things, including constitutional law, media and entertainment law, anti-discrimination law, race and sexuality, law and psychology, and others. And then finally, in cleanup, will be Micah Schwartzman. Micah is the director of the Karsh Center for Law and Democracy and the Hardy Cross Dillard Professor of Law at the University of Virginia School of Law. And I just want to drop a footnote to say that it's been a rough week at the UVA, and their hearts were with all of you. Micah is a scholar who focuses on law and religion, on jurisprudence, political philosophy, and constitutional law. He joined the faculty of UVA in 2007. He clerks on the 4th Circuit Court of Appeals, and his work, rather like Bill's, has appeared in many illustrious places, including Harvard, University of Chicago, the Supreme Court Review, Law and Philosophy, and many others. He also published prolifically in public media like the New York Times, the Washington Post, and so on. Right now, he's co-authoring a forthcoming casebook on constitutional law and religion. Very journey. So, with no further ado, let me turn things over to Rick. I'm going to invite everyone about 10 minutes, I think, is what we agreed to, and I will be absolutely vicious in enforcing that rule.
I have a hard time seeing you can be vicious. I want to echo the thanks to the members already extended to the students for putting this together. Overall, a fabulous job and seamless, great. And I'm especially grateful to my longtime friend Mary Rose Andrea for including me in this. It's always nice to see old friends and have them. So also say I'm grateful to Eric for not mentioning this crowd. I went to college at a school up the road, and this is the most Carolina fans I've seen since a pleasant day last spring. I just want to say I'm having a lot more fun today. So about 18 years ago, I came to a symposium in the College of Responsibility here, also in the religion classes. I gave a paper arguing that the Supreme Court should invalidate the application of state billing on the exercise. And if Marty Leader at the time, like President Breyer, said that I was nuts, and he was right. But the Supreme Court didn't come around to do this spring, so this symposium gets results. So I'm Justice Breyer. I didn't know him well, but I certainly have the greatest respect for, as Dean Chemerinsky said earlier this morning, his unfailing civility, charity, and grace, dealing not only with his colleagues but with other clerks. One of my fondest memories from my first year, we took Justice Breyer to lunch, and he was again charming and funny as you'd expect. But we did have to work really hard to get him to stop talking so loud about pending cases at home. Interestingly, for this panel, Justice Breyer never really authored, and my case we heard about earlier today, didn't author majority opinions setting out the doctrine for the Supreme Court in the religion clauses area. But I think he did have a very distinctive approach and a distinctive legacy, particularly in the Establishment Clause appeal. For me, three things stand out. I'm only going to talk about one of them in detail, but I think I'll mention all three. One is the kind of prosaic point that he departed fairly regularly from the stricter understanding of the no establishment rule that some of his colleagues in the more liberal wing of the court endorsed. You'll hear more about this from my friend Mike in a little bit. I suspect we disagree about the merits of the department, but it was interesting at a time when so often the court does seem to use cases to be divided along party nomination lines. He wasn't locked into that. A second feature is one that I think Dean Chemerinsky talked about a lot of the free speech context. Is that Justice Breyer was entirely candid about his view that you couldn't enforce the Establishment Clause with reference to particular bright line tests. He never pretended to propose a grand unified theory of how to resolve Establishment Clause cases. He was skeptical about when a test maybe before it was cool. And he was, again, quite upfront in saying that he thought the way you had to decide these cases was inevitably by applying what he called reasoned judgment in the context of particular facts and circumstances and contexts. Now, one result of this is that sometimes his approach to Establishment Clause cases could seem unpredictable or perhaps inconsistent. But nevertheless, it does seem like the court is entering into a space that's not all that different from what Justice Breyer was suggesting. That is, turning away from a particular test with various prongs, like the Lemon test, and instead trying to decide cases with regard to more general considerations. Which brings me to the thing I do want to talk about, and that is Justice Breyer's, I think, signature contribution to the Establishment Clause was the suggestion that judges should evaluate state action with an eye toward whether or not the state action in question threatened to cause what he called religious strife or political division along religious lines. And so, again, case after case, and particularly in 4 cases where he wrote separate opinions on them, came out in different ways in these cases. That we heard from Dean Chemerinsky, he upheld one of the 10 commandments qualities, but some of the school aid cases he came out more on the separationist side. But his lodestar was not a particular test to whether the effects were this or that. Instead, he said we should identify what we think the purposes of the Establishment Clause were. And one of those, he believed, was to reduce the potential for, quoting, political divisiveness along religious lines. And the judges used sort of their best judgment as to which result, which resolution of a case would either exacerbate or alleviate that kind of division. Now, about 15 years ago, I wrote a hyper-long, really excessively annotated, sprawling, and unending law review article about justice, which I said it was misguided. Clearly, I didn't have any success in convincing it to come around to my review.
I also did have some success in convincing Bill Martin. I'm not going to go into more detail on this. I'm not going to give the full genealogy of Justice Breyer's approach. It does have roots that go back deeper. Justice Frankfurter, I think, some of the school fair cases, particularly the Chief Justice Berger's opinion in Lemon versus Curzon. But I just want to suggest, and I have left before I go past them, that some of the reservations that I have, it's never been clear to me what the alleged connection is in his mind between, first, the existence or the prediction of political disagreement, the quote-unquote religious nature of the subject matter, which people say to disagree, the religious beliefs or identifications of those people who are doing the disagreeing, and the text history structure without clause. Clearly, Breyer's claim is that this factor of political divisiveness is the Rosetta Stone for identifying establishment clause violations. But that was never entirely clear to me. In my view, the method that he set out for all of his candor was not particularly well suited to the judicial role and duties, while it sometimes yielded results that coincided with it wasn't pretty. So just a few quick points about some of my reservations about Justice Breyer's approach. And again, Marshall will tell you a lot more. First, this does have to do with kind of history and purpose and so on. The Justice Breyer's premise is that one can identify it as the premier purpose of the Establishment Clause is to eliminate or at least reduce religious strife, religious divisions along religious lines. And I think we could probably agree that strife is suboptimal, but I'm not convinced that Justice Breyer actually did the work to identify with any precision what the actual purpose of the Establishment Clause was. It might have been much more prosaic than that. A second concern I have is that it always struck me that his approach was somewhat, again, for all of his candor, redundant in that there were some more rule-based, rule-like inquiries that judges can engage in that will yield a number of the same results as the ones that Justice Breyer prefers. And yet they're not tethered as explicitly as his approach is to judges' prediction, judges' intuitions about the hygiene of our political discourse. A third concern I have is that Justice Breyer's approach rests on a premise that I think is contestable. And that is, it's not at all clear to me that religious matters or religious arguments are more divisive than any other. And it's not clear to me that judgment along religious lines, to the extent we can identify it, is categorically worse than any other kind. Indeed, the argument might be said to fail to take account of the extent to which religious claims can possibly reduce divisions in our society. Another concern I have is that the test that Justice Breyer, again, we would say the test, the approach that Justice Breyer proposes to us is very difficult to administer. And again, it's difficult to reconcile with my understanding of the judicial notion. And it's difficult in at least two ways. It's difficult as an empirical matter, because we don't really know what counts as division, and we don't know how much strife is too much. We don't know how confident we have to be that a particular policy is going to cause unrest and so on. But it's also difficult conceptually. In the earlier version of the test that Chief Justice Berger has set out, the late Chief Justice said, look, we have a lot of pressing issues in our politics, and it would be bad for our democracy if we were to be distracted by issues implicating the religious law. And it's just not clear to me at all how a judge is supposed to go about identifying those issues that deserve our attention and those where our attention should be to be averted. And relatedly, on the conceptual problem, it's not clear to me how one identifies an issue or a policy as being, in quotes, religious as opposed to being something else. People can disagree about matters for all kinds of reasons. The fact that those disagreements might track denominational differences or religious differences doesn't seem to me to be very. And then finally, for now, I think Justice Breyer's argument in this in a way is ironic, given how dedicated he was in a lot of his work and also in his active liberty vote to to democracy. Justice Breyer's approach to me is profoundly undemocratic. It does seem that he is assuming for himself the capacity to tell people with enacting a particular policy that policy ought not to be enacted because in Justice Breyer's view, it might result in or could result in, or in the past has resulted in divisiveness that he finds unattractive. So just to sum up for now, and maybe we can develop this more Q&A if people are interested. It strikes me that this topic connects Justice Breyer's religion clause work to his speech work in a way that I think is kind of interesting. There was a free speech teacher at the University of Virginia for many years, Lillian Revere, who identified an approach to First Amendment law that she called managerial. That some judges, she suggested, take a managerial approach to the marketplace of ideas, to free speech doctrine, and so on. The idea here being, I think, that judges can decide cases and develop doctrine in such a way to make our politics work better, to make our marketplace of ideas healthier. And that strikes, I think that approach is probably misguided. The better way to think about both speech and religion is in what in Revere's word, non-interference or non-distortion type way. It seems to me that pluralism and disagreement are perennial features of our life together. It's not going to go away. And then Justice Breyer's approach to solving establishment clause questions in the end is not effective. Not effective.
Live stream folks are having a bit of a hard time hearing. So let me ask all of our speakers to just bring the mic in closer and maybe bend it a little bit down towards your mouth. Thanks, Bill.
Hey, everybody, it's nice to see you all. Thanks to Rachel and Kendall. Thanks particularly to David and Mary Rose for putting on this wonderful program. I also want to add two other things because it's the first conference I've ever been to that the two people I'm most indebted to for my entire career have to be in the room. The one that Jeff Stone, Jeff taught me creative speech at the University of Chicago. The class was the best class I ever took in law school. He taught me not just about the amendment, he taught me how to teach. And he taught me the energy and electricity you have to try to put in the classroom. I'm saying this for two reasons. One is to thank you, Jeff, and the other is to tell my students to get off my teaching early. The second person who had the marks back in my career, the other person a little bit earlier, Erwin was on the faculty at law that took a chance and hired me for my first week job. And in the decades since then, he has been an incredibly close friend of mine. He has taught me so much about constitutional law, taught me so much about life. It's been incredible in what he's given me. I don't want to emphasize that I'm going to go in one direction because I think this is online speaking. Los Angeles. I know who's calling about it. I think it's first in Utah. When I finished the car before I finished driving, basically, LA was the US state. But one for me, I have to talk about the business and really actually has persuaded me on part of it, or he doesn't persuade me on the business. The role of divisiveness in the public schools in particular. Justice Breyer's legacy, we talked about it this morning, on June 27, 2005, we came up with two decisions on the Ten Commandments, which we diametrically opposed, and that confusion will be his legacy, I think, going forward forever. The second part of his legacy, Rick just pointed out, which is talking about the role of divisiveness. And when Justice Breyer talked about that, he looked back at the 19th century and what went on with the Protestants fighting with the public schools and the Catholics fighting again. subsidies to subsidize the religious schools they created because they didn't want their kids to have to go to public school that was private and prayer. The interesting thing about the division is incorporating how it differs from other aspects of the establishment clause is that at least for others on the legal side, they look to the effects of the establishment of religion on outsiders. So the coercion test, not whether people are being coerced to take a particular religious view, and the anti-endorsement test was Justice O'Connor was associated with looking at whether or not people were being regulated by the government. And the business, on the other hand, focuses on insight. And it focuses on the motivations of religious groups to literally fight with each other for government approval. There is some mention of that in the majority, but it's prior to Justice Breyer going on the court in the County, the first school prayer case, and also in Fleming versus Cooksey, which dealt with this past term. Justice Breyer repeated his concerns about the discipline in his dissent in the school funding department. But he was absent without leave in what I think was the most distant case ever, which was Kennedy versus Breyer School District. And in that case, what was an issue was a public school suspending a football coach because the football coach went and had prayer at the 50-yard line right after a football game. And in one of the most dishonest opinions in the history of the Supreme Court, Justice Gorsuch somehow concluded that when a football coach went into the 50-yard line right after a football game, that person was somehow engaging in private speech. And then also went on and argued that when a football coach goes and engages in particular action, that doesn't create some sort of coercion on other members of the team. For any people who've ever played team sports, just ask yourself, does that comport with reality at all? But after coming up with those holdings, they upheld, they indicated the suspensions are anyway. They struck down the suspension and said it was unconstitutional, but violated Coach Kennedy's free speech rights and free exercise rights to be denied to go out of the 50-yard. And I think it's part of Kennedy, the Supreme Court, particularly I think Justice Alito has said this a lot, and I would be concerned that there's too much religion has been excluded from the law. Clearly, part of the reaction to it. But whether or not this is the appropriate reaction to that, whether there should be a reaction to that, I think is beside the point. At least in terms of what kind of reaction this would trigger. Just imagine that if one coach is engaging in one prayer here, it's going to encourage other people to engage in their various kinds of prayers throughout the school day. If a coach is no longer engaging, working for the school, engaging in private speech on the 50-yard line, right after a football game, and it's even study hall. And there's something called, the psychologists call the mimetic reaction, that people are not really motivated to do something if nobody gets anything, but if I give $10 to 10 of you and don't give $10 to the other 10 of you, it creates some sort of notion that maybe we should get involved too. Something, and I think in this area, it manifests itself as a desire to get government endorsement. That's not a problem when nobody's getting government endorsement, but I think it creates a real problem when you know there's a private government endorsement out there. If you see one religious group getting it, then another religious group is going to get it as well, and that is, I think, a lesson of the 19th century that poor ignores in this case. It goes further. Because the logic of the Kennedy case is to bring back school prayer. Let me explain why. Because when Justice Gorsuch was going through that, he said, first of all, what Coach Kennedy did wasn't coercion. And again, we just talked about that. If that's not coercion, I don't know what is. It's probably more coercive for a football coach to do something with respect to their football players than it is for there to be voluntary prayer in the school. So I don't think coercion, at least as it's understood or applied by Gorsuch in the Breyer case, would strike down school prayer. The other test that Gorsuch offered was, we're going to say there's only establishing a violation when that accords with history and faithfully reflects the understanding of the founding fathers. That's a quote. School prayer is not even consistent with that history. There was a school prayer at the time of the founding fathers. So we see where the history of the movement. And even if we take a look at the enactment of the 14th Amendment, so I think that the logical conclusion of Kennedy, at least in fact, is going to be applied going forward, although I have no statement anything honestly going forward. They haven't shown so that school prayer would be upheld. The problem with that again is not again a reaction of outside. I think it's a legitimate factor. In fact, some students might feel alienated. I think the bigger problem again is this is going to encourage divisiveness along religious lines. Who's praying? The court upheld legislative prayer in another case, and that's already led to political campaigns being waged on the basis of who's prayer. The public schools is often been included by Justice Frankfurt once upon a time, and they are the symbol of our democracy and the most pervasive means of promoting our common destiny. If that's true, they are a real goal and are a real way to try to capture. And if one group sees that captured by one religious group, a logical reaction to the other one, they're going to try that as well. So we're going to see campaigns like the vote for heresy is the vote for heresy, or vote for Schmidt, the vote for the real religious tradition. This kind of concern, I think, is the real reason that we look at the establishment clause as a whole, it never really is the same test. It applied a much stricter standard of separation in the public school than it did in any other context. And I think it did so precisely for this reason, because it knew how particularly divisive fights over school prayer might be. The question, as I see it, really isn't should there be school prayer? The question is whose prayer? And that is a particularly divisive question. So I think Rick may be right that there is no reason to include.
Yeah,
For a 10-minute system.
we had a 15-minute.
We had
Yeah, a couple more minutes.
Yeah, so we had internally agreed to test the bill.
We're going to make a beautifully consistent, powerful argument.
A lot more than 5 minutes.
But I did want to compensate. I mean, I understand it. I agree with it. I do understand the arguments of a lot of religious folks. They really did understand that everything can be in the public school, like sort of religion, inequality. I do think that's we have an establishment clause for a reason that does single out religion. And it might not be equal, as I point as we have everything in the public school, but religion is not completely neutral. I think it's the second neutrality because it isn't separate. It isn't separate. It's something else. I gave a talk last week to the Federal Society of Washington, and I also want to talk about today. But I ended up with be careful what you wish for when you're going to this particular road. Because one of the purposes we found this out in the law was the concern that the vacuum of religion promoted civil strife and promoted wars and justice. Another concern was there was nothing worse for religion than having voted back. Those who lived through having prayer in the schools, they really didn't teach much respect for prayer and with respect for religion. In one particular case, they thought they had a shooter bottle they didn't do. You're weakening it, and all you have to do is take a look at the European experiment, where they had two things. One, established churches that went to kinds of fights and wars that we talked about. And when they haven't into that, they went to what the current situation is in Europe, which is they have a much weakened religious experience compared to the United States. The United States is much more weakened than Europe. So for those who say that this is a great idea, and let's bring back prayer, be careful what you wish.
Good afternoon, it's great to be here. I spent a summer at UNC when I was in college, so I have fond memories of the community. Thank you to Barry Rhodes for organizing this, for reaching the other organizers. A caveat, my project is not systematic, but I do want to think more about the project, so the paper is it's a work in progress. It actually is that paper here, but it's and it's specifically to editing versions in U.S. constitutional law. And I'm evaluating transformations in the court's understanding of power information over decades, and some shifts that I think are generally unconsidered. And trying to sort of indicate that she's concerned about how these shifts happen. They're often not made. Really matters to the decision who gets protection from the court. So I'm trying to show connections and disconnections between equal protection law and the exercise doctrine. I wanted to also establishment. I'm not there yet. I get this decision. Figure out how to do that. Historically, the courts get examination workers pursuant to its interpretation of the protection clause. The court invoked different analytical pathways in key cases like Brown v. Board of Education and Love v. Virginia. Some cases focused on racial classification and subject to strict scrutiny, but elsewhere the court inferred discriminatory intent in history and context in a fairly loose way. And so my colleague Ian Lopez this contextual intent is not a blindness to this topic. Other scholars have called this animus review, and so I'll sort of say more about how this animus review is ended up being very important in a certain cases. In the 70s and 80s, the protection doctrine coalesced around this, requiring that the plaintiff must show a racial or gender classification of the treatment scrutiny. The key cases of the Georgia case, where you have this bonus study showing quite convincingly most scholars think racial bias, but it's not that vitamin classification. And so the court says it shows the purpose, which is basically malice. In this individual case. And then Massachusetts versus Feeney, a veterans preference case. Again, we see, even though there's strong evidence of the veterans preference benefiting them, I believe 98% of the veterans in Massachusetts were men. The court didn't see a sort of perfect, pristine classification that benefited exclusively men, and therefore it says you have to show malice, and I think it overlooked good evidence of contextual intent in that case. In the 90s, we see a shift. As equal protection becomes primarily the province of white plaintiffs challenging affirmative action policies because of the court's fixation on racial classifications, the court began to extend equality to LGBT people, but most of these cases involved in Rome in the 60s, Colorado established a single gay, lesbian, and bisexual institution as ineligible for specific discrimination prevention at the state and local level. Justice Kennedy wrote the majority opinion, which declined to apply any conventional equal protection standard. Instead, he deployed a variant of contextual intent. So the term animus sort of goes mainstream through Breyer and through sexual cases. So I think that actually this is the same mode the court once used race cases before the sort of classification approach. And we maybe would go on to sort of lead the court in these opinions like Lawrence versus Texas, Corporate Bell versus Kindness, which tended to blend liberty and equality, and the equality analysis often that's required. Was novel, but also sort of unclear simply what Kennedy was saying, unless there was a sense of any that would say that. So for 120 years, such a change, the
central site of progress. Throughout this era, we see conservative centers, Justice Alito, the more recent Justice Alito, vociferously arguing the core institutional protection of the case of lesbians victimized in traditional religious moral values. In his work of dissent, Justice Alito described religious people as marginalized, which means that we typically think of as a people of color, women, and sexual minorities. He said, by imposing its own views of the entire country, the majority facilitates the marginalization of many Americans who have traditional ideas. Recalling the harsh treatment of gays and lesbians in the past, some may think that is fair play. So, in short, according to Alito, the flip side of LGBT equality is discrimination against traditional religions, and he sees basically traditional religious people falling into the status of gays and lesbians through the court's opinions. Very striking. Things began to change in 2018 with Justice Kennedy wrote on his final opinions of masturbation. The narrow opinion was joined by justices as disparate as Alito and Justice Breyer. Case featured this evangelical motivatory and refused to make a case to celebrate the union of two men. He argued that applying the state and discrimination law to his business would violate his right of free exercise. So here we have competing claims of victimization. One of the points of this paper is sort of saying how the court usually looks at the real evidence to figure out what is the nature of the discrimination in the state with respect to LGBT people or with respect to their religious. It's certainly sort of assumptions and sort of basic orientation about the world, doing a lot of work that is often not tethered to empirical evidence. So the court, Justice Kennedy, the court expressed concern for LGBT equality and suggested that discrimination laws at the state level are generally constitutional, but he ultimately depicts the baker as the real victim. He latches on this Breyer remarks in the record by a state commissioner that he says show anti-Christian bias. So I wrote a piece that sort of takes Kennedy to task of this, and I'm sort of speaking of ways as somebody who's Christian and also gay and black. Sort of saying, actually, things that you think are offensive, my pastor says that all the time. He sort of admits the ways in which the Christian faith has been used, unfortunately, to harm marginalized people throughout history. Which not only to reject Christianity, but to call that bias against Christianity is, I think, not something that a lot of Christians actually believe in. And so, again, one of the challenges here is just to use their own personal view of what counts as bias in debate, and not having any sort of external sources. Kennedy doesn't sort of cite anything to sort of back up his sense of what counts as Christian bias in this part of the debate. After this Kennedy's retirement, the court continued to innovate doctrinally and finding that evangelicals and conservative Catholics have been victimized by the state under the free exercise and establishment clauses. Some cases, such as Fulton versus Philadelphia, involved a contest between LGBT people and a religious organization. I think we also have to pay attention to other cases that have maybe not been fully examined in the worship cases. There we see the court developing, I think, novel and controversial understandings of religious bias. So, like this analysis in the Rome, the court's reasoning is often brief, and optimistic, and undeveloped. It is as if the bias is so obvious to the majority that it doesn't need to explain it. In the Roman Catholic diocese in versus Cuomo, the 2020 case, and New York borders shut down houses of worship because of the risk of COVID transmission. The plaintiffs argued that the treatment of places of worship constituted discrimination. So the question really was, what is the comparative about comparing churches and synagogues to a big box store, to a weapon shop? The justices who were around the comparators, the majority really didn't explain why it was choosing certain comparisons. And I think when we look at the district court's very convincing analysis that the order doesn't target religion, it targets the gatherings. People in houses of worship arrive and leave at the same time, physically greet one another, sit or stand close together, share last objects, and sing or chant in a way that allows for the transmission of the virus. They often have pre-existing relationships as in the concept of church family. This intimacy facilitates COVID transmission. I think these features distinguish houses of worship from big box stores, liquor stores. You go to a big box store, you're not really gathering with them and singing with them. At least I don't do that. Which of course sought anti-religious violence. Right? So justice courts have provided the most conservative condemnation of the U.S. Senate. Only as it relates to religious places differently seems to be a judgment that what happens there just isn't as essential as what happens in secular spaces. Because it crystallizes this thing that again, the state is tuning out on religion, and the court has to step in to protect vulnerable religions, and often it's actually Christians who still make a majority of that as a country, right? So there's this odd sense that sort of like the majority can themselves and the court stepping in to protect Christians who don't still stand up for laws and policies that are very Muslims, and of course Trump, which is why he is a complete step on that there are others. So I'll stop there.
Now I have my.
No, so did we grab it quicker? Practice so far. This. Great. Right. Great. My title on today is Compromise or Appeasement of Post-Mortem Justice Breyer's Establishment Clause Jurisprudence. I want to start by taking us back to Justice Breyer's retirement in January of 2022. He's been under intense policy flux with the private presidency. Justice previously, but there was heat on Justice Breyer in the court while Democrats hold the presidency and they were hold on the Senate. But you might also recall that shortly before we had Justice Breyer publishing a book and making a legitimate on this. There we go. This book called The Authority of the Court Politics. I mean, his main argument is that the decisions were built on a public trust, and the court had earned acceptance of its decisions for generations by affirming the rule of law. Justice Breyer argued that we should not take this for granted that the public obeys the court's legal decisions. That is his view. An impressive institutional accomplishment, one to which we should, he argued, accord great value. And the book is addressed to what I'm going to call Breyer's question, and I'll just read it for you. The book says, if we cannot take for granted that the public will accept the Supreme Court's decision, how can we build or maintain a system that makes it more likely? And he answers this question in the book as short. So he answers this question by drawing a distinction between law and politics. He says the court is engaged in making legal decisions. Justices are legal actors, they're not mere political partisans. And the primary argument of the book is to make out this distinction. I think it's fair to say that this argument has not convinced anyone who wasn't already persuaded by it, and in my view, it's a very good argument. So I'm just going to set it aside. Responses to this argument, Leah Lippman has a trenchant review of Justice Breyer's book on this ammunition law review laying out this claim and responses to it. So I just want to bracket this thing. I actually think there's a more interesting argument in this short book, which comes later in the book and which has not received the same amount of attention. And it's an argument based on the value of compromise. And the argument I think could be used to reconstruct Breyer's argument, and this subsidiary argument about compromise could be used to reconstruct the overall argument. Like you can say, even if Supreme Court justices do make political decisions, at least in the kinds of cases that reach the Supreme Court, they might still earn the public's trust by reaching compromise solutions to difficult political problems. Maybe the justices turn out to be good if they compromise instead of reaching moderate results, especially when our politics are so polarized and divisive. And so here's a second answer to Justice Breyer's question about how the court can maintain its legitimacy, even if the justices do act politically, they can reach compromises with each other for the sake of peacefully resolving important conflicts. Justice Breyer doesn't give a definition in his book for the idea of compromise, even though he spends 15 pages talking about compromise and how the court might engage with it. It's a big chunk of a small book. So I borrowed a definition of philosopher. He wrote, I think, one of the most interesting, insightful, and sympathetic accounts of compromise in recent philosophical literature. And here's what he says. He said, a clear case of sanguine compromise, which I think is the kind of compromise that Breyer is pointing to, is an agreement with a promise that involves painful recognition of the other side, giving up with dreams, making mutual concessions that express recognition of the other's point of view, and it's not based on coercion of one side or the other. And I think Breyer is suggesting that judges ought to engage in this kind of compromise, at least in some cases, when they're faced with conflicts. That is, they should make mutual concession. They should recognize what's being argued on the other side. And I want to say a few points about this idea. The first is that I think the religion clause cases, many of them, provide examples where Justice Breyer seems to engage in making compromises. The second point I want to make is that in some recent work with Justice Nelson, Teddy, and Cornell, I've argued that Breyer's efforts to achieve compromises collapse into what we describe as an appeasement strategy. So I want to distinguish between the process of compromise and appeasement. And lastly, I want to mention some costs of following an appeasement strategy, because the costs that I think work against some of Breyer's reasons for pursuing compromise in the first place. Okay, so let me give you a few examples. Dean Chemerinsky already began discussing the Ten Commandments cases, and I think we've seen some scorn heaped in this direction already today. But as you recall, under Erie County, Justice Breyer votes to say that the Establishment Clause is violated by displaying the Commandments, along with a lot of other symbols. In a Kentucky case, but then he turns around in Van Orden versus Perry. These are companion cases in the same year. Let's see if this works. Oh, sorry, I'll turn it off. There we go. This is Van Orden versus Perry. This is the Ten Commandments case involving display of Ten Commandments on the grounds of the Texas State Capitol. And here, Breyer says this Ten Commandments is permissible. And let me just give you the voting arrangements from Mr. Boyes, right? In the first, Breyer's in the majority with liberal justices and Justice O'Connor, and in the second, O'Connor votes to not to allow the Ten Commandments in the Texas Capitol, and Breyer was the Supreme Court, so 5-4 going in favor. And this is one of the most unusual alignments I think we ever saw really in an Establishment Clause opinion. So 5-4 decision with Breyer is swinging through of a religious governance symbol. But this isn't the only set of circumstances in which Breyer joins conservatives to allow governments to support their religion. Let me give you a few examples, a few more. One is Trinity Lutheran involving government funding for a school that wanted to be part of a program for resurfacing playgrounds. The state excluded the school on religious grounds, and Justice Breyer, along with Justice Kagan, joins the conservative majority of 7-2 decision to say that the state is required to provide this funding to this religious organization. That 7-2 pattern alone might have just thought Breyer, on principle views, just thinks that this is a public benefit, like lots of other types of benefits that the state might provide, to fire protection or protection for children's safety, and so on principle grounds. Maybe he thought this was the right outcome. But it turns out that there are a handful of other cases, 7-2 decisions, dissenting Breyer and Kagan and conservatives. This pattern is reflected in a number of other religion clause decisions. Let me mention a few. Masterpiece Cake Shop, that's the case involving many members who rejected complying with public accommodations law. Right here, Justice Breyer and Kagan joined the conservative majority. American Legion, that's the Latin cross of the bottom, and the state support this symbol, 7-2 with some Americans for dissenting Breyer, again with the conservatives majority, and little systems involving contraception and whether office required to provide it in prior joining the conservative majority. And there are some other cases. So here's the list. In all of these decisions, we've got 7-2 outcomes in which Breyer and Kate joined the conservative majority, Ginsburg, and so on like this. And the question I want to ask is what's going on? Why are Breyer and Kate joining conservatives to create lopsided majorities in these decisions? So one answer to that question is Breyer's engaged in a compromise strategy. Things what he's doing is ameliorating some conflicts, reaching narrow incremental decisions, and trying to avert further losses on progressive view. But one thing that might be going on here instead of a compromise strategy is, again, perhaps politically, a strategy in which Justice Breyer is engaged in appeasement. And I define it here as a strategy of asymmetric concessions by one party for the purpose of avoiding conflict. That's an intention requirement. The party has to aim at that as opposed to trying to aim at some principle first best outcome. But avoiding conflict with the self-defeating effect of holding the opposing party to take more assertive actions. Now, appeasement is, of course, a loaded term historically, and I'm not accusing Justice Breyer of being Neville Chamberlain. I wanted to explain the historical analogy, but it turns out to be really hard to find another term that does the same kind of work. Basically, when you're describing a failed compromise that ends up with self-defeating outcomes, the phrase we typically use, and it's widely used in public media, and as a political majority, the phrase we use is appeasement. I mean it in this technical sense, so I don't want to rely on this historical analogy, but I do want to suggest that Justice Breyer's compromise strategy has led to negative outcomes in all three major areas of religious laws and jurisprudence. When we're dealing with religious exceptions, in the pandemic cases, the conservative majority blows through limits that Breyer set. In the funding cases, Trinity Lutheran is 7-2, but the cases in the same line that follow it, Espinoza and Carson Smith can find Breyer with nothing to show for the compromise that he reached in Trinity Lutheran. The court goes right past the limits that he set, and also in symbols, as you mentioned, in Breyer, if Breyer thought he was laying down any kind of line in the cost case there, plates for again, all of that is swept away. So I don't think that Breyer has much to show if he was engaged in compromise in these earlier cases as much to show. They don't look like reciprocal concessions. What they look like is concessions that are disproportionate or asymmetric, in which one party is now taking advantage of another. And I think Breyer's career in which he clauses functions in some ways as caution too. That is, if you're trying to meet your colleagues halfway or split the difference with them, there has to be some reasonable expectation of reciprocity. And recently, I don't think that expectation is plausible. Having learned those lessons following the death of Justice Ginsburg and now Breyer's retirement, I suspect that this era of what I'm suggesting is appeasement is over. And the postmortem is just that. I think that's what was going on here, and that it will not continue in the future. We're entering a period of increasingly polarized tension and sustained dissent. Thank you.
I'm going to invoke moderator's privilege here and ask the first question, and then you should all your questions because in a moment we'll open up the mic. The thing I wanted to note that startles me at least a little bit is that this was a conversation about Justice Breyer and religion clauses in particular. Stephen Breyer is Jewish. Stephen Breyer was born in 1938. He grew up in the shadow of the Holocaust. He emerged into the legal world at a time when many opportunities were not available for Jews. So I wonder just about the absence. I'm not arguing the massive psychobiography here, but it does strike me as curious that Breyer's religion is not relevant or didn't surface in the discussion of his views about religion and the Constitution. Wondering if anybody has a comment.
So one, I'm always reluctant to attribute the jurisprudence of justice to their religious background. I think this is a treacherous area to begin. I think there certainly are Jews in a certain generation And I think this is some compromise, because of this sort of attitude. You think, look, given the background culture of the country like the United States, on allowing religious expression to be permitted, which is really in minority position with respect to that expression. And you know, there has to be some recognition of that and acceptance of it. And working just behind that, but I think is something like a view, which is, I don't know how to characterize this, but I sort of want to slogan, don't pose the bear. Right? Like, don't push it too hard, because the backlash, the results will be really bad for religious. So make some compromises to allow some expression of this kind, because the alternative will be much worse for you. And so in some ways, I think the divisiveness point is part of a general attitude of compromise, especially in the accommodation of public religion. That can be a function of his just minority status.
Thank you. When you were talking about easement, that was part of it was getting into my mind. So thank you. Any other comments?
Yeah, I'm not gonna try to just Breyer's faith to the impeachment strategy, but I would just say in general, I think minorities of various stripes, whether it's sexual minorities, racial minorities, religious minorities, one of the ways that we survive is toning down identities, blending in, appeasing, not making too much trouble. I think there's a lot of politics here because of the identity work that the minorities of various stripes do in workplaces. I think it applies in many contexts. So I think some of this is about us being immigrants and raising them to this talk. Don't sit down, just figure out how to change the name, do all these things that are written in. So I think that's always a good issue. That's how pretty sure about that. But the only thing that's is nothing. This is very depicting that is faith and spiritual engagement. I'm pretty sure his daughter is in school. And he meditates until we're like the family moments where conscience is like, tell me when he's meditating. So I resist a little bit of this to one things that are very complex and interesting.
Thank you. Questions from the audience, comments, reactions?
I'm not here to ruin the party this time, I promise. I actually do have a question. Anyone's free to answer, but Professor Robinson, you mentioned how sometimes the court doesn't look to empirical evidence. It's more of a sort of a what our presumption or what our assumptions of what a particular group experiences. And then Professor Schwartzman, you spoke about this concept of compromise, this concept of appeasement. In this time, increasing divisiveness, this is less about Breyer and more just about what you see going forward. Just what do you think the court is going to be like from now on, especially with, as you said, Professor Schwartzman, Breyer's tactic of appeasement didn't really work. So is the answer appeasement? Is it continuing to be staunch in our beliefs? Is it, I'm just looking for some overall reason.
I don't know that I have any sort of rosy expectations for the future. Let's encourage that the political takeaway from the midterms is one of the takeaways is that jobs are Republicans. And so I hope that at least some of the justices of the conservative majority think twice in terms of realizing that the public is watching and that they can sort of obviously in the affirmative action cases, many of us would want to sort of see, is there any movement, is there any middle, right? Is there any swinginess right after Kennedy or political speed is probably the so that's kind of the next big question that will give us the future direction of the court. That at least with respect to racial discrimination.
I suppose I think the progressives, the minority is so small at this point that there isn't, I think, the same kind of room that maybe Breyer might have felt like he had at different points in his career to play a role in being a compromiser. That space is narrow and systematic. The debates about scope and limits of free exercise and establishment laws happen within the conservative majority. And I think the role for progressives at this point is mainly one of dissent. And here I think they've got models. The models are of justices like Scalia, Marcus, who spent decades dissenting in these cases and announcing principles and announcing approaches that were disfavored by the court for many, many years in the hopes that they would be developed by others, that they would be more systematically worked out, and that at some point they're going to come. And I don't think that was really Breyer's approach in some of these cases, but I suspect it will be the approach of some of the other liberal and progressive justices.
I think this line of discussion kind of ties into what was said this morning about Breyer versus their line. I think Breyer, I think the multi like references. I just believe in law. They believe in this book. They believe that there will be discussion and people could faith to come together. And it's that would be more today than it is the period that it came from. And we seem to be at a different period right now, or I think this is a big more of the agenda than anything else.
I sort of say it's more so, but I think the compromise with appeasement maybe leaves out of their option to that Justice Breyer arrived at outcomes they felt correct, and they happen to be in the two sides. And that strikes me as being as well supported the evidence as the in which case it worked fine because they expressed well how he thought the establishment clause ought to be enforced.
So particularly in complaints for prosecutors, it seemed like Breyer was willing to accept sort of the historical analysis. When this process has been here for 90 years, and so it's okay to keep it here. And I think that sort of historical analysis is one that most people associate with conservative justices, and is one that can extend beyond the establishment clause or establishment clause cases. So as Breyer been willing to join with conservatives in that kind of analysis in other areas as well, or it's been pretty limited to first.
What you heard earlier today, the speech panel, and all of those people know a lot more about the free speech document than I do. But my sense is that in some areas, Justice Breyer has drawn on history, tradition, and practice in order to identify the kind of things that are at play as a proportionality analysis. So that's what the beginning of as well. Sorry.
Yeah, I think his view there, Ryan, is less on the jurisprudence looking to history and practice, but it is really on the legitimate beliefs that it's something that's been around for a long time. It gets ingrained in the culture. Legitimize that in this particular area. And Justice Breyer believed that too for some things. It wasn't just Breyer first on that. And I think that Breyer said so deeply ingrained in our culture that we are going to take it out, recognizing particular religious history. So I'm not sure it's an overarching jurisprudence tradition. Really more about this kind of first possession model. And it's something's around one.
Just follow up on that. So it strikes me that there's probably a pretty broad consensus in this room everywhere else that it wouldn't make sense for justices to set about really eliminating all public religious symbology or naming or things like that. I'm not going to change the name of San Francisco or whatever. Everybody agrees about it. And then I think there's probably a shared consensus that there could be religious apology that would go too far, like the danger, no establishment commitments. So, just for you, I mean, prior to the line, some places it was kind of intuitive. Where do you think you should draw it different?
You know what? I think I much lower than our, we know what we see it pretty close to establishment. And I think in the, but you couldn't figure out on the importance of this going on, but an alternative to me was take a look at it, reasonable observer, and then they see it to be an endorsement. Who that reasonable observer is going to depend a lot on the religious background, it's going to depend on your amendment. But I do think the inquiry is subjective, and it's really hard to get out of that in any real way, other than letting the precedents build upon themselves. So, yeah, I don't think the court's going to strike down a guy which has the national motto, and they're going to strike down Los Angeles. But there's not going to be any particular hard and fast line. I think that Breyer, when he decided that true word he did, I'm sure it's smartly given second members came about that's accountable, but when I would say any of the justices would have taken the picture that down as the Department of Justice, for example.
So I had a question, Professor Marshall and Burnett kind of spoke about divisiveness and the test that they come up for if the state action calls strife, religious strife, and things like that. And I grew up in the church and as a pastor, so I know more than anything like how divisive religion can be at its core in the first instance, like how to just apart a church can be. And I just find it hard to kind of reconcile to say like, okay, if something is divisive amongst various religions, then that's, that's not okay. But just religion seems divisive, period. That's what I'm thinking. And I'm just like, how can that be the test or the argument or the question of whether something is divisive, whether something causes strife, if that is such at its core. And it's inherent, and so it's just like, what else could there be? What else can we look at? Because I feel like if that's the question, then the answer's always there.
I agree with you. I don't agree with you. I don't think that this can be the be-all and end-all for every single establishment. But I do think the public schools are special, and I do think on the other side of things, creates a different, intense kind of divisiveness that's not of the identity of the religion itself. It's not just different views that, Rick makes this point. Because he different views on issues like abortion, it's a big different religious view on all kinds of issues. It's a good idea to get multiple ideas there. But when you're talking about putting prayer in the public school, you're asking which is the preferred religion, period. Which one are we putting the authority of the state behind? And that's a different kind of existential question than fighting about other kinds of political battles. It's a fight for which religion is officially sanctioned. And I think what the real insight of the early prayer cases was, let's take the public school away from that. Now, let's not let religious control of the public school be a political goal, and if we do, we'll eliminate that kind of problem. So, yeah, there's going to be religious strife no matter what, but I think there's certain kinds of this that the court recognized and attempted. I think they had it right then. Rick, I think might disagree. So go on.
Actually, I think that's be boring. I agree with a lot of that. It's just to clarify, I'm not always clear, I'm often unclear. My objection to Justice Breyer's approach is not that I'm unbothered by political strife, religious division, and all that. I think it's in many ways to be regretted, even though I suspect, like the questioner just said, it's ineradicable entirely. My reservations are more kind of doctrine geek-ish, in that I don't think it's a workable approach to establishing deciding establishment clause cases to kind of consult one's own sense of whether a policy is likely permissible. Better, it seems to me, to devise kind of rule-like doctrines that when you apply them in a rule-like way, maybe they'll have a nice benefit of right, vision and so on. To some extent, at least, I guess the question says, with this side edit.
How are we for time? I'm not sure. Are we? Yeah, it's 1:30, so well,
let's wrap it up. So let's extend
more thanks to our wonderful panelists for a very, very interesting discussion. Thank you.
Thank you all so much. That concludes the second panel. We're now going to take a 15-minute break. See you back here at 1:45. I'm going to moderate our third and final panel titled Justice Breyer and Future First Amendment Challenges.
Thank you so much to everyone who's made this day magical so far. But this last panel is going to be the most magical one of all. This is the first, to my knowledge, the first and only time that we have brought on stage 3 of the most eminent First Amendment scholars in the country. They're all 3 here. We also invited Keith Charles from Harvard Law School. And unfortunately, he had a family emergency and was unable to join us, so we miss him today. But I think the reason we have this panel and we're making history here is because no one dared to invite all 3 to the same conference. That's how you know thrilled I am that they're here. I'm going to do some brief introductions, and then the format for this is actually going to be more of a moderated conversation rather than lengthy presentations. At the same time, we welcome your questions, and I expect many. This again is a historic opportunity for you to get insights from these amazing scholars. So I'm not going to spend too much time introducing Dean Erwin Chemerinsky, except for those who were not watching this morning, just to mention that he is Dean of Berkeley Law School. He's written, well, maybe more, may have written another book overnight, but he's written 13 books and for 200 law review articles. And if you haven't noticed, he lectures without notes all the time. To my right, I have Jeff Stone, who has been my mentor for many, many years. He is the Edward H. Lee Distinguished Service Professor at the University of Chicago. He served as a law clerk to Supreme Court Justice William Brennan Jr., later served as Dean of the Law School, the Provost of the University of Chicago. He's the author of many books, including National Security Leaks of the Freedom of the Press, Democracy and Equality, the Enduring Constitutional Vision of the Warren Court, The Free Speech Century. He has an upcoming book coming out on abortion. He has many, many other accomplishments. But one thing I want to mention, actually, he didn't get listed biography that I learned last night, is that he was the chair of the committee that authored the Chicago Principles. And indeed, they're properly known. They originally were named the Stone Principles. So I'm now going to refer to them as the Stone Principles from now on. So thank you so much for coming today, Jeff. And then the other panelist we have today is Bob Post, who is the Sterling Professor of Law at Yale Law School. He served as the school's 16th dean from 2009 to 2017. And before Yale, he taught at Berkeley. He specializes in constitutional law with an emphasis on the First Amendment. He's also a legal historian who's currently writing volume 10 of the Oliver Wendell Holmes devised history of the Supreme Court of the United States, which will cover 1921 to 30, when William Howard Taft was the Chief Justice. He's also written many books, including, I'll just note, Democracy, Expertise, and Academic Freedom, a First Amendment Jurisprudence for the Modern State. And something also not in his bio is that Justice Breyer cited him many times in his opinions. So we are beyond fortunate to have these gentlemen with us today. Before we start, let me just offer a couple more remarks about why we're having this symposium, why I was obsessed or am obsessed with thinking about Justice Breyer's work. One thing I want to start with is the arc of history is long, and I think for those of us like me who went to law school, a few decades ago now, times change, right? And so we don't know that Justice Breyer's approach, which is a very distinctive approach to First Amendment questions and resonates with countries around the world, but might indeed one day become the dominant approach here in the United States. So it's worthwhile for that reason alone to consider what is that approach and whether it has value and what are the strengths and what are the weaknesses. More recently, though, I became obsessed with the McAvoy, with Justice Breyer because of his decision in the McAvoy case, which we've already heard mentioned a few times today, particularly in Dean Jurisprudence opening remarks. That was the student speech case. The student posting on Snapchat, fuck everything. And remarkably, Justice Breyer wrote the majority for the court. He didn't write a lot of First Amendment majority opinions. It was 8-1. And it really, I think we're going to talk today about what that opinion, what is going on in that opinion. Is it proportionality? I'm not even sure it is, but most of the court joined it. And so I'm curious, the same court that has announced that we use text history and tradition to resolve most First Amendment cases, that is not what they did in the McAvoy case. I also have been intrigued with his majority opinion with Walker versus Texas case, which is the specialty license plate case. Again, he had a majority in that case 5-4, and that also doesn't track a typical text history and tradition approach. So basically one of the questions today to the panelists will be, what's up with that? All right, so we put together talk more about where is the court going? We have the ruined that Second Amendment opinion where the court, Justice Thomas said that we use text history and tradition to resolve First Amendment cases, and I think Clay Calvert earlier today pointed out that's sometimes true, but mostly incorrect. And in any event, it seems to me the court is on the precipice of perhaps great change in this area. Maybe not. And so using Justice Breyer as a lens, we're going to explore what is the future of the First Amendment. To get us started, I'm going to have you, Jeff, talk a little bit about the lessons we've learned. You've written about this in a few essays about the lessons we've learned about the First Amendment in the first 100 years of jurisprudence at the court. And so I thought it might help get us started by summarizing what these lessons are that we've learned and offer some thoughts on how Breyer's approach to the First Amendment is consistent or inconsistent with these lessons.
Thank you. I'm honored and delighted to be here, although it's very sobering to realize that I'm the oldest person in the group. That never happened until recently. And it's really a pleasure. It's also a pleasure to be in an event where so many of the participants, people I very much admire. I won't mention who they are, though, so if I fail to mention someone, I can get sued for defamation. But certainly these two guys are among those of my most admired very long period of time. So, as Mary Rose stated, I've written a piece and then elaborated on a couple of other places about the 10 lessons that the court has learned over the first century of its interpretation of the First Amendment. And I'll go through some of them here to get us started. The first thing to understand about it is that the court didn't start with any of the current documents. It didn't know squat about how to interpret the First Amendment. And deciding a large number of cases over a long period of time, they came to agreement on a range of different principles and doctrines that were designed to serve several, I think, valuable purposes, creating a jurisprudence in the First Amendment. So the first one is simply learning the lessons of experience. That is, over time, the justices were able to realize that prior decisions were wrong, that they hadn't understood the subtlety of free speech as a concept. They hadn't understood the need to be cautious about the abuse of power by the majority, and to develop a real distrust of government regulation of speech. That was not there from the very beginning. And also to understand the importance of people having opportunities for speech and not to allow the government to overregulate that. But these are things that may seem obvious to us today, but were not really vetted in the court's jurisprudence for at least the first 50 to 75 years. But they've learned that now quite well, and that shapes a lot of what they do. They've learned it, that's the important. They've learned it, and they've learned it because of free speech. People criticize their opinions, they heard that, learned from it, and they modified their jurisprudence. Second lesson is they rejected several possible approaches. One of them is absolutism, that literalism. Congress will make a law for freedom of speech for the press couldn't possibly mean what it says. First of all, noted earlier, shouldn't be limited to Congress. Second of all, no one knows what a bridge means, and it's not clear what freedom of speech and freedom of press is. So even though one might look at that and say, okay, that's clear, it isn't, and they figured that out, and it was important. But they also learned to reject ad hoc balancing as across the board approach, because it would be so unpredictable that it would create enormous problems in producing a structure of free speech that would be protective of the core values of the First Amendment. And they also rejected the idea of having a unitary standard that would be one standard to test all free speech cases, because realistically that's not going to work, because there are different problems that are raised by different free speech cases. Third thing they've learned is you need, for as clear as possible, rules for dealing with free speech cases. Ambiguity in jurisprudence of the First Amendment creates all sorts of opportunities for abuse, and both by state legislatures, Congress, and juries, and so on. And there's a need for people to have an understanding of whether they do or do not have the right to get engaged in particular speech, because of the chilling effect. Any single person, the value any single person gets from speaking, the impact it will have on the number of people whose minds have been changed is small. And if you know there's a risk of going to jail for giving a speech, or marching in the parade, or whatever, a lot of people can say, never mind. And so it's very important in order to have a robust system of free expression, to essentially have that kind of a clear understanding of what the rules are. So getting to the rules, one of the basic ones that over time adopted was the distinction between content-based and content-neutral restrictions. That was not self-evident in the beginning. In the beginning, the court sort of engaged in more or less ad hoc balancing. But they recognized over time that laws that regulate content are potentially more dangerous under the First Amendment than laws that are content neutral. So content-based laws, an example of a content-based law, one that says you can't have political signs on your front. You can only have political signs on your front lawn, or you can't have political signs on your front lawn, or you can only have political billboards. You can't have political billboards. Those are content-based, and the reason to see that those are more problematic. But as the law says, no one can put up a billboard. No one can have signs on his front lawn. That's less than problematic because the risk of the government engaging in some form of discrimination from types of speech is less when it's neutral than when it's about content. Then beyond that, they learn that there's an important distinction between content-based and viewpoint-based distinction. So the difference between nobody can have political signs on the front lawn and nobody can have signs on the front lawn supporting Republicans is dramatically from the standpoint of the First Amendment. And over time, they came to understand that and develop a distinction within the realm of content-based distinction between content-based and viewpoint-based. And the last one I'll mention is the concept of low-value speech. That is, the court beginning the Symposium case came to recognize there are certain categories of speech that, mainly for historical reasons, but also because they don't seem to serve the purposes of the First Amendment in the same way that other types of speech does, are not entitled to the same degree of protection. Excuse me, that is illustrated by things like defamation, obscenity, threats, and commercial advertising. And the court recognized that partly for historical reasons, partly for value reasons, that they can be regulated differently than other forms of content and viewpoint-based restrictions. But the court also recognized recently that they don't want to be in the position of recognizing new categories of low-value speech, because that gives them power to do something that they shouldn't be talking about. And so they define this now as those categories that long been regulated by standards much less than the normal perspectives of free speech. So those are some of the principles that I think the court has settled upon, more or less settled upon, over the course of the past century. The others on this mention briefly, one is about government speech, one is about incidental effects on speech, another is about government employee speech, and the other is about public forum, all of which shifted the standard because of the categories. Now, it's clear that this has not produced a perfect degree of clarity, right? Except maybe for viewpoint-based discrimination. All of those standards have ambiguities about them. But they enable lower courts, lawyers, to understand what standards apply, at least, in any given situation. And lower courts over time have tended to come to an understanding of how they should apply. In the Supreme Court, there's often a good deal more confusion in the cases than in the lower court, because the only cases they take are the ones with real confusion. And so one sees a lot more ambiguity in the court's jurisprudence at the Supreme Court level than I think one does in the lower courts, who understand, for the most part, what the current language should be. Breyer's approach, I'll say just briefly, underscoring what I've heard already a lot earlier, is in an important way to keep compatible with what I think the court rightly recognized in having these fairly defined categories. The idea of having a proportionality approach makes everything up for grabs and makes it unclear what rights people have and don't have, what restrictions the government can make and can't make. And that degree of uncertainty and ambiguity, again, reinforces the chilling effect and reinforces the ability of government to regulate things in ways that are based on impermissible motivations, but which they are careful to hide. So I think that his embrace of that approach, which might have seemed perfectly sensible 100 years ago, really is not only consistent with current jurisprudence, which is not perfect, but which I think opens the door to exactly the kind of uncertainty and ambiguity that we're having in people understanding, lower courts understanding what the First Amendment means in any given situation. So I don't have to go on.
No, thank you so much. I asked you to summarize 100 years, so you did a great job. I'm going to turn to you now. I'd love for you to describe a little bit more Justice Breyer's approach as you see it to First Amendment questions, and particularly, what do you consider the greatest benefits of this approach, and what are its possible weaknesses? And along the way, feel free to mention any specific cases if you wish.
Thank you. It's a great pleasure to be here. It's an honor to be on this panel. I think I'm brought on here to be the dissenter. Because in my view, First Amendment doctrine now is a bloody mess, and it's going to get worse and worse and worse. So I'm starting from a different place, not one of just celebration of what the court has discovered, but some dissatisfaction with the court, what the court is doing.
I just want to start with Mike's presentation of the previous panel and the idea of peace. But I think to understand Breyer, understand where it comes from being Senator Kennedy's ally. He comes from being in the Congress. His idea of being constructive is negotiating, getting to a settlement, and his whole life he imagines himself as dealing with people who disagree, coming together, reaching an agreement. This is his whole idea. And when he was on the court, he imagined he reached out and took immense pains to reach out to every other justice, no matter how much he disagreed with them. And he understood himself to be almost like a best friend to even the justices you would imagine to work with. And he did that, in his view, to sort of cut down the harsh edges and to reach whatever agreements he could. Now, in retrospect, you can call that appeasement. Another way to call that is playing for time. If you're dealt a losing hand, play for time. Sometimes you win and sometimes you lose. And it's a little, in my view, kind of harsh to call it appeasement in the sense of you're just giving it away, as opposed to you might have a losing hand if you could choose the other side of the river and then get your ground appointed, right? Then you'd have a different situation. So it all really depends on contingencies beyond his control. What he was doing from his point of view, and his idea of what it was to be a justice was to reach what agreements he could within the court, and that's both his strength and his weakness. So it's the opposite of a justice like Sotomayor or Scalia, both of whom imagine a voice that reaches out beyond the court to the general public and mobilizes the general public. I think this is what my meant when he was on dissent, you know, to mobilize the public to demand different kind of jurisprudence. That's never been his strength. Breyer never really, he's trying to reach out to the general public. He's close and read the reviews, exactly his preaching and what kind of mobilization, but a mobilizing figure, he's not. He's always from the inside, dealing elite to elite, trying to get a consensus among those who have power at the given moment to do it. I think he'd like to be like sort of minority black and have a clarion voice. And every once in a while, I think that's involved, just kind of gets there. But for the most part, that's not his genre, that's not his voice. And he doesn't consider that his issue. So that's point one about him. Point two, he is someone who is a pragmatist. So he says, we have law, and why do we have law? We have law in order to accomplish the purposes that we want to achieve. That's the point of law. And sometimes you can achieve those purposes by having a rule, and sometimes you can't achieve those purposes by having a rule because the rules start cutting in all kinds of different ways. So the idea of content discrimination became, after this Reed case that you've heard talk about, the same thing, a total nightmare for the lower courts. Reed said any rule that turned on the content of speech would be content discrimination and subject to strict scrutiny. So many things follow from that. And one thing that follows from that is a very important difference that Jeff just talked about between viewpoint content discrimination, because everything is escalated up to the strict scrutiny. Or another thing, we make all kinds of distinctions based on content, all kinds of very good reasons. And this became like a cleaver. And the lower courts, they were not given guidance. They had a very different standard, and then it wasn't decided. You had decided 15 cases that acted as though it hadn't been decided. This just made no sense as a rule. So rules sometimes make sense. And very often in an area like the First Amendment, they do not make sense. And why is that? Because they are to apply to speech. But speech isn't one thing. Speech is many different things. And what makes sense with regard to political speech does not make sense with respect to commercial speech, does not make sense with respect to the speech of doctors and their patients, does not make sense with respect to speech in a courtroom, does not make sense with respect to speech in school. Very hard to make one rule that's going to make sense in all those different contexts, even though they're all speech, right? And he was very aware of that, Breyer. And so he did not like the statement of clear that in rules, except where there was something that could get across the board. The speech is so various and applies to so many different domains. It's very divided, and I think it's very rare to find a rule that would make sense across those broad domains, across that immense geography which covers speech. So he was more likely to say, what do we want to achieve by intervening as it were to protect speech? And let's fashion our interventions by what we want to achieve. We want to protect democracy. Does this intervention help or hurt democracy? So one question that you might think about as you learn law is whether clarity comes from a rule or clarity comes from clarity about what your purposes are. These are two different forms of clarity. So a lot of people look at the IRS code, a lot of rules. What the hell does it mean? The fact that you have a lot of clear rules doesn't make clarity, doesn't make transparency. It often makes confusion. Whereas if you know what you want to achieve, and then you think about what you're doing relative to what you want to achieve, it can create more unity and more cohesion and more integrity in your decision making. That was his approach, I think, to the law. My criticism of him in terms of his approach to First Amendment doctrine is that he had, from my taste, too much of a reliance on what I would call trans-substantive tests. And these are the tiers of scrutiny that Earl was talking about earlier, which are put into the First Amendment from equal protection doctrine. So equal protection doctrine, tier of scrutiny makes sense because your fundamental values, equal equality, are people who are similarly situated, being treated equally. So you talk about things like narrative, et cetera, et cetera. That's not the point of the First Amendment. Part of the First Amendment is quite different, and we can debate about what it is. Let's not say it's to promote participation in the formation of public opinion. Just take that as one possibility. So if that's the point, the issue is a tier of scrutiny. The issue is how does a state intervention or state action affect that goal? And you want to derive a lot of things from that goal, thinking about that goal hard enough. But these tiers of scrutiny actually don't ask anything at all about the goal. They ask irrelevant questions like narrowly tailored or compelling purpose or necessary or lesser restrictive alternatives. Why not? Those are all tests which are so easily manipulated. I mean, any court which can't think of a less restrictive alternative is really the dumb. It's the easiest thing in the world. You can always come up with it if you want it. And the issue is, do you want to? And then, do you want to or not? Should depend on whether the rule is effectuating the purpose. So these important to voluntary discretion, actually, they open up tons of discretion. And when you start debating things over these levels of scrutiny, you are, to my mind, missing the point. So take a very simple case here, Alvarez, which I think you mentioned earlier. Right? So Alvarez was a case where we had something called the Stolen Valor Act. Made it a crime to falsely claim that you received a medal from a U.S. military, in this case, Congressional Medal of Honor. So somebody is talking before a school board, city council, public works commission, and he says, I didn't love the Medal of Honor of the state, and he didn't. So he gets prosecuted. And the debate in court is between those who say there should be intermediate scrutiny and those who say there should be strict scrutiny against that. Tell me more. What's the First Amendment value at stake here? Why do we care whether this is being regulated? Now, you could do that by, in my view, asking two very simple questions about Alvarez, like about any First Amendment case. First question is, what is being regulated? And the second question is, why are you regulating? So, why are you regulating false claims about the medal? And the answer is very clear. Every justice who wrote about the case was clear about that. We want to maintain the reputation of the medal. We don't want to tarnish the reputation. Well, we know from basic First Amendment theory that one of the things we don't want the government doing is intervening to form public opinion. We don't want the government to tell us how to think about something. Well, what is it to say your purpose is to prevent tarnishing your reputation? Because we don't want you thinking badly about this. That's the point of the statute. The statute's bad right there. You don't have to say anything about tier of scrutiny. Just look at what's being happened. Second question, to what does this apply?
Well, it turns out, again, every justice who looked at the case said the problem with this case is it applies to everything. It applies to somebody sitting at home saying to their child, son, when I was in World War II, and the prosecutor was worried about that, because it gives such great discretion to the prosecutor. Why do we worry about giving too great discretion to the prosecutor? Because if everything is subject to prosecution, then the prosecutor prosecutes selectively and for the wrong reasons. For the wrong reasons, it's exactly like I'm doing it because I don't like you. You know that that's a bad thing, right? You should be prosecuted not because they don't like your views. So those are two very basic problems with the statute. No justice on them. Instead, they talk about these irrelevant things like series of scrutiny, which didn't get to the heart of the problem. And so when you start to formulate your First Amendment test in these oblique and abstract ways, you start missing the point of the First Amendment pretensions. Where if we get back to basic First Amendment theory, what do you care about? You can solve most of these cases in a pretty simple way. And the reason, in my view, that First Amendment cases like Sorrell, which we're going to talk about, are going off the rails, it's because no one's bothering to ask why we did the First Amendment in the first place. Instead, you get platitudes like the remedy is more speech or marketplace of ideas. I mean, the supreme parody of this was an recent case called Lithgow, which was about California requiring a posting of the availability of reproductive rights services in something called CBCs, which falsely claim to be offering reproductive rights services. And the question came up in the case: is there a special First Amendment rule for professional speech? So of course we treat professional speech differently. When your doctor says to you, you've got cancer, you got to get your arm amputated. It turns out it's a mistake, and you sue the doctor doesn't get to say, oh, it's an experiment, like all life is an experiment. We don't talk like that. We want people to divide what the doctor says. Of course we're going to treat speech differently. You'd have to be a moron not to treat speech of your advantage of your point of view. And you get Thomas, when he says this, he says the reason why we don't have a special category of professional speech, we want the marketplace of ideas with professional speech. I surely hope this doctor doesn't function according to the marketplace of ideas that he celebrates. That would be crazy. With regard, and we're not talking about doctors speaking in public, we're not talking about Dr. Oz, you understand it. We're not talking about we're talking about professional speech, doctors practicing medicine through speech, which they do, or if that's too abstract, lawyers. I'm giving an opinion letter to my client, and if I'm making it up, I'm liable. And I can't say marketplace of ideas, and I hope Justice Thomas's lawyers don't say that to him. But you get this, you get right off the shelf these bromides about these First Amendment and nothing to do with the situation. And when you see cases constructed with that level of professional ineptitude and indifference to the actual speech acts which are at stake, of course the doctor's going to go to hell. And that's what's happening.
I see Erwin grabbing the mic, and I'm not.
I'm just saying how wonderful it is and how humbled I would be on this panel. Young people in legal education I admire more for their brilliance, for their kindness that Jeff's talking about the place. And in this, I didn't think, well, Marshall was kind of, Bill, you're right, the car wasn't a piece of junk. I say a lot more about Bill, but I only want to say to the students who are here today, you're so incredibly fortunate, Bill, your professor. It's interesting as I listen to Jeff and then Robert, I think that some of it is when Jeff is mostly descriptive, and I agree completely with his description. And what Robert was doing is much more normative. I agree with a lot, but not all of your. Let me just run several things that I disagree with. First, if the general rules aren't designing, then have particularized rules for particular areas. My criticism of Justice Breyer is neither was willing to prescribe general rules nor have particularized rules. I think you make a very good point that speech applies in many different contexts. It's hard to have overall rules. But when you think about the higher school district, if you don't want to have a general set of rules with regards that apply to schools, then at least with regard to schools, give guidance in terms of how and when can they regulate social media. The problem with 100 cases, it doesn't give any guidance to school administrators, let alone lower courts dealing with the issue. Second, I do think I'm more of a fan of the levels of scrutiny than you are, because I think they ultimately ask the right question. If it's something that we care greatly about, then we want the government to interfere only if it has a compelling interest. And if we are willing to trust the government, then I think the question is right in terms of legitimacy. I think, as I said, we can modify that in particular instances, but I think there is a logic behind the levels of scrutiny that's desirable. Again, when you think of the fact the Supreme Court's going to decide so few cases, the overwhelming majority of decided lower courts need some guidance in what it has to use. Third, I very much agree with you in terms of looking at the purpose of the First Amendment. The difficulty is there are so many different purposes of the First Amendment. I don't know that it's going to help a great deal in courts deciding where to go to, especially when it's the lower courts and say, look at all these different purposes of the First Amendment. And I think in a sense that you're being unfair in the criticism of Justice Kennedy's opinion in Alvarez, because one of the most important things that Justice Kennedy focused on is to what extent does the First Amendment protect false speech? That was really the issue in that case. Falsely claimed to see that alone. It did get a great deal of attention in Justice Kennedy's opinion. I think it's a much harder issue than Justice Kennedy gave it credit for, because we're now seeing in the context of social media and internet, a huge problem with false speech when tools to deal with it. But I think that the result for bringing to an Alvarez was exactly right. Answer. I agree with you that I think Nicola versus Becerra was a terrible decision, but I think it was terrible for reasons beyond what you described. That I think the court was wrong to regard this as compelled speech. No clinic had to say anything to any patient. All they had to do was post a truthful statement on their wall. For some, it was a truthful statement that the state would pay for free abortion and contraception for women for reporting. For others, it was a very non-controversial statement that it wasn't a licensed facility right medical care. And I think that what explains Nicola versus Becerra isn't First Amendment doctrine, but it was the court's hostility.
Oh, yes, of course.
So I totally agree with that. Although the compelled speech cases are such that they might have used it even if it wasn't they're going so over the top with the compelled speech. But I agree with you in terms of, I know it's not getting an account of the case, but let's talk about Alvarez and let's talk about the school. What's that? How do you pronounce that?
Also, while we're pausing, make sure you get close to your mic so the online audience can hear you. Play.
It's Baja Zoe pronounced.
So, the question is false speech protected? That's it's very hard to make a general statement about that. It's plainly protected if you're taking if you're defaming a public official. It's plainly not protected if you're selling toothpaste. So to formulate a question like that might be to misformulate the question. That's why I think Alvarez goes off, because it formulates the wrong question. The way in which it formulates the question actually comes off of something which Harry Calvin called the two-level theory of the First Amendment. Two-level theory is all speech is protected unless it's fighting words, unless it's obscenity, unless it's a true threat. You have a set of exceptions. And Jeff was rightly talking about how in a recent case called Stevens, the court refuses to add to those exceptions. But the problem is the formulation of the problem. All speech isn't protected unless that's not the way speech works, and all speech isn't protected the same unless. And so when you formulate that way, you formulate a question that's like, would you ask speech in life? Because we have different kinds of speech which are subject to all different kinds of protection. It's not on-off switch. These are the categories that turn the First Amendment on. So when the whole analysis is formulated around the question, it's no wonder that the case is going in a modern circle. But let's talk about the modern day. We wanted to see it from its two public rights. And he says that the function of doctrine is to give evidence to lower courts.
So, to my mind, one of the elements is to illuminate the states. You see what's at stake, and you can understand the stakes and apply them as best you can in the complex situation that we're facing. That's different than the question. Right. So, what are the stakes in mind? In a school, we protect ordinary freedom of speech so that the state can be responsive to what we want. This is strong word. This is the origins of our free speech doctrine. This is Whitney, right? We get together, we try to form a public opinion. We want the state to be responsive to public opinion. We want the state to make laws in response to what we wanted to make laws. That's that. And so when we speak in public discourse, we're sovereign. Autonomous. The state can't tell us what to talk about. There's no content discrimination in public discourse. The state can't tell us what view to take, can't tell viewpoints, etc., etc. But now, once we've got together and decided what to do, how does the state act? So let's say we want to get together and we want to make an institution that will give healthcare. How would we do that? We make an organization that dispenses healthcare. How would that speech work in the organization? The speech in the organization would be everyone gets to decide and say whatever they want. You've got an organization and it's organized to accomplish the purpose of the organization. And so speech within the organization will be regulated to attain the goal of the organization. A school is like that. We organize a school in order to educate students. That's why to speak about freedom of speech in school as though it was a form of freedom of speech in a newspaper is to make a false comparison. Any speech which disrupts the school, which is inconsistent with the mission of the school, and we have to be clear about defining the mission because it's part of education and open-mindedness and all of that. But I can't stand on my desk and sing if the teacher's asking me a question. I can't march up and down in the middle of a lesson. I can't not shut up. I have to answer a question. There's compelled speech in school all the time. We call that what? Grades. Right. There's viewpoint discrimination and content discrimination. You'll write a paper about First Amendment. You'll write a paper about 30 years ago. We do all of that in the school. It violates every single rule of First Amendment doctrine that we have within the school routinely, and it does it to accomplish a particular purpose, which is education. So we understand and we all accept the regulation of speech of students who are in school. But then the question is, what does it need to be in school? And that's the question. This is a posting outside the school, not using school resources about the school. So does the authority of the school, which they would have, this woman were to walk up to her teacher and say, "Fuck you," to the teacher, she would be disciplined in school, no question. Right? But this is now not in the school. But is it not in the school? That's the question that the court was trying to decide. And of course, that's not a rule question. That's a question of more or less. That's a question of what factors you consider. The authority of the school leads out in very complicated ways. It can be more encompassing when you're dealing with bullying, and less encompassing when you're dealing with a one-off kind of speech, etc., etc. It's going to be hard to figure out what the dimensions of authority are in the school outside of the geographical boundaries of the school, etc. And that's what Breyer's opinion is trying to isolate. He's trying to tell you the factors and the point of asking these questions, and when you're going to come to your own conclusion. So my own intuition is that gives you guidance because it tells you what you're trying to find out, whereas a straight out rule would actually mislead you and make suggestions. But what could differ on that?
I would say you shouldn't have a rule, but then articulate a rule that says speech inconsistent with the mission of the school to be able to stop. I disagree with that rule, so then you articulate your rule.
A few observations or comments on this. First of all, I think that the public school issue is like a range of other contexts, which the court has said are ordinary principles and doctrines of going back. So government speech by government employees, speech by prisoners, speech by members of the military, speech by students and faculty members in public schools. Those are all situations which the court has recognized that those are circumstances in which it would not be sensible to apply the same standards that we do in public discourse. And I think that again, is a good distinction. And it does leave a certain degree of ambiguity, as all rules inevitably do. But that creates also a degree of clarity that would not otherwise exist. I think that's really important. And of course, as I said, the rules that have been adopted over a long period of time. Doesn't mean they're all perfect, they're not. But I don't think we want to improve them by creating ad hoc decision making. And part of the reason for that is you don't trust government to regulate. That's one of the critical purposes and reasons for speech action. And the more ambiguity you have in the doctrine, the more opportunity there is for government to suppress speech because the majority doesn't like it. And that's what a lot of these doctrines are designed to address. And that's what the report is so critical. Because basically the report discrimination is almost inevitably unconstitutional. And the reason that we don't want the government deciding which viewpoints are okay and which are not okay. And we also want to make sure that we give people a degree of clarity. The chilling effect that ambiguity problem is enormous in coming up with a workable system of free speech. Or having rules that are as clear as possible, I think makes an enormous difference. And again, with the lower courts, I think it has a very positive effect. You know, the ambiguities of the basic rules are mostly focused on the Supreme Court does. Lower courts does something inevitably. But I do think that the idea of relatively straightforward rules is terrific. I also agree with Robert about Reed v. Gilbert and Breyer's dissent in the subsequent case against the application to that in Bar v. Association of Political Consultants. Reed, as you've heard already, for the first time after the viewpoint contact distinction came into place, basically said, no, it's just content. And you can't treat distinctions based on content any differently than distinctions based on viewpoint. And that, in my view, is one of the worst decisions that the court has handed down. As Robert said, lower courts are disregarding it almost across the board, so they understand the problem. You don't want to apply strict scrutiny of the sort you apply to viewpoint-based decisions, the content-based decisions, because the content-based decisions are all over the place. And what's inevitably going to happen, if they actually adopt that notion, is that the protection that's given against viewpoint decisions will be diluted. And that would be a disaster in terms of protection of free speech. So I do think that the notion of an open-ended understanding of the First Amendment is usable, is worthwhile if you're trying to change the doctrines, but not as an approach in and of itself that makes very much sense.
You all should know that the reason why the court came to see content discrimination was bad was because of the magnificent article that Jeff wrote in the 1970s.
I recommend that.
Yeah, I remember reading it when I was taking. If you want to offer some more comments, Jeff, on cases you thought right, I think Bob had mentioned some of them already, cases where I think Breyer got it right or maybe wrong.
I think Breyer got it right on the campaign finance position, all dissents basically. I think his understanding of those cases is that these are content, not viewpoint-based restrictions. A law that says Republicans can spend more than Democrats explicitly would clearly be viewpoint and unconstitutional distinction. But campaign finance laws are not viewpoint-based. They're content-based, with regulating political speech, but nonetheless, they don't have the same evil as it would be to say that Republicans spend more or less than Democrats. And I think that Breyer, along with most of the other liberal justices that we serve, is correct in saying that therefore the standard of justification is less than it would be in a viewpoint-based situation. And that the government's interest is very important here. That we do not want to have a democracy in which billionaires or corporations are able to dominate the process. You can imagine if in presidential debates, the moderator said, okay, who wants to have the first comment? I have been. Right. And that was the way the debate proceeded, right? We would regard that as absurd, right? And Breyer and his brethren in this area recognize that this is not the kind of restriction that raises the most serious question. And that having a degree of equality or approximate equality in the campaign finance context is really critical to a well-functioning democracy. And so that's an area where I think he was definitely right, although the majority would disagree with him. I also agree that he was right in attacking the Reed case. And I think that's, as I said earlier, a very important difference. I think he was right, as I think it was Robert noticed, in the initial case, I both of them mentioned it, in the initial case, recognizing that requiring these abortion-related organizations to give medical advice to put up a sign that says that the state offers treatment for pregnancy and so on is professional regulation, and not requiring them to speak themselves any more than requiring a lawyer to speak Miranda or police officer to Miranda words is a violation of the First Amendment. And again, the majority there took the wrong approach, and I think Breyer was right in presenting. I think where he was wrong, one example is the Brown v. Entertainment Merchants Association case involving video games, which Irma talked about earlier, where he said in his applying a very open-ended analysis that the court should uphold laws regulating violent video games because the parent interest is significant, and balancing and taking a proportionality test, this should be okay. The majority, in my view, rightly said, we don't want to go, we don't want to create that ambiguity, confusion. We've never allowed that violent speech is not fully protected by the First Amendment. And we've never basically said, except in the pornography context, that speech could be regulated for children outside schools differently than it is for adults. And I think the majority was right there. Another case where I think he was wrong was the Alvarez case, which we talked about already, where the court basically said that they were going to limit the pure low value judgment for false statements of fact for only those categories that had historically been recognized as subject to regulation: defamation, perjury, fraud, for example. But once you open the doors, Breyer that false statements of fact are invaluable, and therefore government can regulate them under these very unclear standards. Then that can be easily abused by the government. If they can make it a crime for a politician or a person running for public office to make a false statement, they will prosecute people from the other party. And given that it's dangerous. So I think that having clear rules in situations like that is very valuable. And I think he was wrong in his opinion, concurrently.
Robert Post, I can go back to, I'm wondering if it would help Justice Breyer's reputation, I suppose, of the popularity and proportionality inquiry if he engaged in it in a more structured way. So I think one of the concerns I had about the Vanderbilt decision, just as an example of stuff, but just as an example, is that it didn't have structure. So, for example, the European courts that indeed do proportionality analysis, I think there's often a structure. I think we heard this morning Clay and others mention sometimes, and Herman, I believe, mentioned that sometimes he mentioned like a four-part approach, but other times it's more this free-form kind of thing. Do you think there would be more merit if it were structured, or do you think it is better than having more open-ended?
So I'm not defending open-ended. Certainly, that in any what are the most structured European proportionality views, I don't think that's much
But what I would want to suggest is that if you actually reason about the substance of the matter instead of the test that's orthogonal to the substance of the matter, you're going to get a better result. So Brown is a good example of that. This is the case about video games and putting labels on video games. So Scalia, he's one very bright sharp rules. So he says video game is a medium for the communication of ideas. It's always protected by the First Amendment, like a movie is all video games. So actually, if you study the law of video games and people suing video games for private publicity or other violations which video games can have, lower courts don't treat video games as though they were protected by the First Amendment. Well, they treat some kind of games and other kind of games they don't. If you're a North Carolina basketball player and there's some kind of video game with North Carolina basketball players on it, and they're using your jersey number, you can sue for violent publicity, which you can't do if they're using your jersey in a movie, for example, which is as a movie. So it turns out that a video game isn't a bright line rule. It turns out that anthropologically we've got different views of different kinds of video games, and yet the bright line rule. Now, when Breyer dissents, he dissents in a whole lot of ad hoc ways, which seem to be more or less irrelevant to what the case is really about, which is what the hell is a video game for purposes of the First Amendment. So I'm not defending ad hoc versus the other. I'm not saying it should be a rule about what the First Amendment is about. And if you have a standard, it ought to be what the First Amendment, and it ought to be addressed in the substance of the First Amendment issue. And like to a degree, you don't. For the most part, they're orthogonal to that. Sometimes they might not have really important issues like a balancing question. So sometimes they do come across that as a rule set, and very often they're relevant to that. And to me, our jurisprudence become clearer as we focus on actually what is the real First Amendment question. And let's fashion stuff around that rather than take tests off the shelf, whether it's proportionality. That's my critique of Breyer, is that and as he gets later, these last few terms, he's come out more and more with direct balancing, as in, like he just did it in the outdoor Reagan advertising case, where he basically says, let's just balance the damn thing. And if you're balancing, you're looking at, you're looking square at the First Amendment states, or square at the other states, and you're doing what courts very often have done in the past, which is to balance. Stevens balances a lot. The court balances in court 80, and many cases court balance. And if you do balance in a subtle way, and you actually look at what matters, it can be very informative. It's not the only way, but it is a way. So the issue is ad hoc. It's not proportionality. It's off the shelf versus actually understanding the relevant First Amendment issues in a way that is illuminating to others, like lower courts who have to conversation. That's what I'm saying.
That's very helpful. And just staying with you for a minute, do you think there's a role? I want to switch and talk about the text tradition methodology. If you just I just stop. Within Breyer's methodology.
Well, if you look at this raining outdoor advertising, which starts to back read. There's a passage in there where Sotomayor gives an obeisance to history and tradition, I think, just to get Kavanaugh's vote. This history and tradition is, to my mind, it's an advertising slogan for a perfume. It really isn't called. That is especially true in the First Amendment area. Because, of course, we had no First Amendment judicial protections until the 1930s. So what are you going to look at when you're looking at history and tradition? What we know from history and tradition, if you care about, say, if you're an originalist, and you care about the original meaning of the First Amendment, it meant no prior restraints. That's what it meant. That's how the court interpreted in the Alien Suspicion Act cases. That's how Story interpreted in the 1830s. That's how Oliver Wendell Holmes interpreted in 1907 in Paxton versus Colorado. He said the First Amendment offers no protection from substantive punishments, only from prior restraints. This was pretty clearly the judicial consensus. And the first cases that I know of, the Supreme Court level, that First Amendment ones. So, just like history and tradition of all places, this place is going to be somewhat partial.
And earlier, you pick up on that. it's interesting that in that Bruin decision, the Second Amendment case, the court said that, in the First Amendment context, we use history, text, and tradition, and want to import that into the Second Amendment. And they certainly have used text, history, tradition when creating new categories or whatnot. But do you see even the conservatives on the court selectively using text, history, tradition as a methodology, or do you think that that'll become more consistent?
Yes, I think that they're selectively using text, history, and tradition to get the conservative results they want. But second, I think what Justice Thomas says in Bruin is even more extreme than text, history, tradition. In terms of the court using text, history, tradition to get their want, I think they do that in Dobbs. Like an essay I just wrote for Jeff Stone. If you read Dobbs, Justice Alito at the end says, quite emphatically, we're not going to overrule any of the other rights under the Liberty of Due Process Clause concerning family autonomy or contraception or same-sex marriage. If that's so, then we're rejecting that it's just about text, history, tradition. That part of Dobbs really isn't relevant. What Dobbs really is about then, it's just about potential life. I think in terms of text history tradition, more generally, the court only follows it when it gets to where it wants to go. Take as an example of the 11th Amendment and sovereign immunity. You can't possibly justify the Supreme Court's 11th Amendment jurisprudence based on the text of the 11th Amendment or the history of the 11th Amendment. It's very much about conservative value choices. And I'll make a prediction, and I think we probably all agree to it. The Supreme Court's about to overrule the affirmative action cases, Bakke, Bruder, Bishop. They're not going to pay any attention to text, history, tradition. They're not going to look into reality. The same Congress that ratified the 14th Amendment also adopt programs that were race conscious, things like the Freedmen's Bureau, or Shelby County versus Holder, where Chief Justice Roberts says Congress has to treat all states the same. That's not about text of the Constitution. It's surely not about history, because the same Congress that ratified the 14th Amendment also passed the Reconstruction Act, creating military rule South. And it's not about tradition, because Congress has long treated states the same. So I think that this is just the guise that they use for their conservative values. But second, I think that the court didn't draw it is much more pernicious than just text, history, and tradition. Justice Thomas said that he's explicitly rejecting looking at the ends that the government's trying to achieve with gun regulations, or the means. And here I think that we should be looking at the ends. Saving lives is something the government should be able to do with regard to gun regulation. He says explicitly, the only kind of regulation of guns that we allow are those that are historically permitted. He says that the Second Amendment makes a judgment that the right to bear arms is more important than all other interests. And so what the court has done in this case, which is different than other original decisions, is usually originalism is used by conservatives to decide whether a right exists. And then the court would apply the levels of scrutiny to decide if the government can do it. Here the court is using originalism both to define the right and to determine what regulations the right are permissible. And just Thomas pretends that it's gone on in the First Amendment context. It hasn't gone on in the First Amendment context. It hasn't gone on in any other context.
I agree with all of that.
Okay. We need another dissenting voice, but I'm sorry. Didn't have one. So Jeff, you posed this question as a suggestion. I thought it was a fun question, sort of a parlor game perhaps. What First Amendment decisions that Breyer supported do you think might be in jeopardy in the future? Conversely, can you think of any decisions where he dissented that might flip the other way in the near future rather than 50 years from now? Who knows?
In thinking about that, I actually found that I couldn't think of very many which are likely to be changed. And that's not to say there won't be significant changes in the First Amendment jurisprudence. There are major areas, but in terms of his own opinions, I did this. This may not be accurate because I did it very casually. It might be interesting for the purposes of the volume to do it in a serious way. But I looked at Breyer's majority concurring dissenting opinions and looked at how he voted. And he actually voted to uphold restrictions on speech 80% of the time. And that was pretty stunning. And I almost ran, so maybe completely wrong, but, and my guess was it was more than any other we could observe. But again, I have no evidence to support that. But I found very striking that there was so much, in upholding, like a whole section of speech. I think what Mickey v. Lawler is one where the court requires approval might be overturned. This was the case where a radio host, the court held would not be punished for knowingly broadcasting a tape of a recording that unlawfully recorded the conversation of two other individuals. And even though the recording is illegal, and even though the reporter knew, radio host knew that it had been illegally recorded, the court held it could not be restricted for that. That's a little bit like many other issues, where the New York Times, Washington Post knew that Ellsberg information was illegally presented to them. And the court nonetheless said that even though Ellsberg could be punished, well, it turned out he wasn't, that the Times and the Post were protected by the First Amendment. But Rardicki is one where I think that the court might be very much of the other direction on a case like that. I actually couldn't think of any of his conservative opinions that I thought would be reversed in my lifetime, which is unfortunate, but one Walker. So Walker, I think, is a really interesting case. Walker is the one in which the state of Texas allows individuals to create license plates providing certain messaging, go Texas or whatever. And he did not turn down any of something like exactly something like 240 requests until the Confederate flag was put up as a proposal, and the organization that monitored these things in the States said no. And the question was whether that violated the First Amendment rights of the organization that wanted to put it up. And Breyer wrote the majority opinion saying this was government speech. And when government speaks, the court has made clear that the normal principles of the First Amendment don't apply. The president in a speech advocates whatever policy he wants without having to have someone else respond and to the opposite side, for example. And so the principle of government speech is basically the government is allowed to speak and is not under any obligation to present views of the law. But in this context, I find it weird to think that the messages on license plates, and there's so many of them, and they're so random, are government speech. And this clearly might involve discrimination against a particular message that I don't have to like. And states can get rid of it without people to put their messages on the license plates if they wish to. But this seems to be clearly viewpoint-based discrimination. And if you imagine the case instead that someone wanted to put Black Lives Matter on their license plate, and the state said, no, you can't do that. I can't imagine Breyer would reach the same result.
So in the next case, when they want to put a cross on their license plate and Texas turns it down, don't you think that Breyer is? It should be.
It's also Breyer is line by Thomas and Ginsburg and Samaria, and it was, Roberts, the conservatives like that. So we got that. I think it's a great example. It's also because I agree much more with the dissent that what the government was doing was creating a forum with private speech. They don't have to allow private groups to put things on the license plate, but once they do, then it is a forum for speech.
Right. I can't understand why Breyer did took the position in the case where the other liberals stand there. Is because calling this government speech is kind of ludicrous. Given the fact that they never turned anything down, and it's on private individual's car, even the license plate is state property. But yeah.
It's also worth noting that Justice Thomas provided a crucial fifth vote, and that was interesting. I was going to ask E to talk more about that. He had written in the past about Virginia v. Black and how that seemed inconsistent with the REB decision, and again, Justice Thomas perhaps providing a crucial vote as well, but because of a particular view he has on that kind of hate speech. So it's not clear, but Justice Thomas did it right separately in the Walker decision, so he ends up joining the majority. It seems inconsistent with his prior jurisprudence, so we'll see what happens.
We talk about I call
You can call it whatever you want, you're just still.
school yes.
Say they have that.
The NA81, small for you, right?
I mean,
That's the advantage in the case.
yes.
Yeah, Brandon is the fun. What I wanted to point out is simply that Mary Rose wrote a terrific orator, Supreme Court review on the case, which I happened to edit, although I didn't have to do much editing. And to capture her point, here's a quote: rather than this is about Breyer, rather than engaging in a careful calibration of the competing interests and a close consideration of settled First Amendment principles, Breyer simply engaged in an ad hoc analysis, and by so doing it creates more problems than it solves, which I think is perfectly right. But I just want to make sure we felt
That's so nice. Do any of you have any thoughts to add on what we heard from the revision clause earlier? Do you think there's, I mean, I didn't generate a lot of questions about that. It seems like the writing's on the wall for where the court's going in this area. But your thoughts on this?
Chris,
I'd love to hear your story.
It's a story. It was something I was going to put in this morning, but it's your argument in where the question that I get asked that I was most proud of my answer to at the time of the oral argument, and that in hindsight, I most wish I could change, was from Breyer about divisiveness. Breyer at the oral argument said he finds it very hard to know where to draw the lines, and that he therefore thinks it's important to look into divisiveness. And my answer was that the 10 Commandments are so divisive. There are protesters outside the court. I received death threats the prior week. This is why it's so important that the 10 Commandments not be indicted. And I thought that was the right answer to that. Well, in hindsight, I wish what I would have said, it wouldn't have made any difference, of course, in the outcome. But any enforcement of the Establishment Clause is inherently divisive. Because any enforcement of the Establishment Clause is always telling the government that it can't do something it wants to advance religion. So divisiveness can't be the test with regard to the Establishment Clause.
Do you have any thoughts to offer after that Kennedy versus Farmington case on the interplay between free exercise and free speech? It seemed like free exercise just gets special treatment, the exercise of religious speech is treated better, perhaps? I'm not sure.
And of course, anytime there's a restriction on someone who wants to pray, there's always a claim that it's violated of free exercise, and always a claim that it's violated of free speech. I think what's interesting about the Gorsuch opinion with regard to speech in Bremerton is it's really backing away somewhat from Garcetti versus Savalas.
Exactly. Sorry.
Garcetti versus Savalas is a 2006 Supreme Court decision that says that there's no First Amendment protection for the speech of government employees on the job, the scope of their duties. And it's a terrible decision because it creates a bright line rule that provides no protection for whistleblowers on the job. Well, the argument here is that Joseph Kennedy was on the job. He was at a football event, which was what his job was all about. It was still during the time of the event. He was still functioning as a football coach. And so I think that when Justice Gorsuch saying, well, this wasn't really speech on the job, because in the words of Justice Alito, it was a lull in the activities, and it wasn't really part of government speaker's duties because he was speaking for himself. I think this opens the door to try to say that there's other instances where Garcetti for Savalas doesn't apply because it's a lull in the activities, or it's not part of the official duties of the job, things like that. I like lessening the absolute nature of Garcetti for Savalas, but I worry this is just going to be something that it's doing in the religion area.
Right, see my forthcoming article on this very topic. It's I really, I totally agree with you, and I don't think the court really, grappled with what it was doing to the free speech side of things, because it was focusing on the free exercise clause, and the Garcetti decision is so absolute, and I'm not a fan in any way, but it does seem like, now you say, well, it wasn't something I was supposed to do on my job, like specifically the employer does not want me to do this, so Garcetti doesn't apply. That I don't think the court necessarily expected there to be such a big road to drive right through with Garcetti.
What do you think they would have done in Mahoney? If it was a teacher who did that?
Social media.
Yes.
Is something. Yeah, it's a different. Yeah, they would use the Garcetti / Connick / Pickering framework, and I'm not even sure they would say it was a matter of public concern. I mean, if they got past Garcetti, which if it weren't, that's the first thing, were they using social media as part of their job duties? It's possible teachers can use social media as part of their job duties, but if they weren't, then the next question would be, is it a matter of public concern? And that was another unsatisfying thing in the McEnroe case that the court suggested, that saying, fuck cheer, fuck everything is a matter of public concern. It just really wasn't clear to me what exactly they thought about that. Not clear to me that it is. Certainly lower courts in similar types of cases have said that that kind of speech is not a matter of public concern. So I don't think the teacher would fare well. Tell your teacher friends not to swear on social media, particularly about anything related to their jobs. That's not wise at the very least. We're ready for some questions, so get your tails up there with some hot questions. I'll have plenty if you don't. All right, that's great.
Rather than the board conversation, I really feel that. Spending your time with us this afternoon. So I want to ask about this exceptional circumstances where the standard of just the First Amendment might not apply. And we've talked a lot about Alvarez. And so I want to ask about sort of electoral exceptions. And that is false speech that is intended to affect the election. Now, in Alvarez, that wasn't the issue because he already had the position on the water board. He just lied in the first meeting later. But nevertheless, Breyer's concurrence in that decision seems to suggest that in the electoral speech context, that a lesser tier of scrutiny might apply, or some form of exceptionalism should be applicable when the speech is directed at getting unelected, or speech that is fraudulent. And I wonder, one, if you see that the court might in the future begin to move in that direction, recognizing exceptions. And then secondly, would that be a good thing? Like James Weinstein is arguing that the government should have more discretion to regulate speech when it affects election outcomes.
I mean, right after Alvarez, there's a case called 281 election committee out of the 8th Circuit. So, there's all this, I'm going to be controversial, but there's all this loaded rhetoric in Kennedy's opinion. Speech is always, whenever you have a problem, more speech is good. And so, you had a Minnesota statute, many statutes in the United States that penalize false speech, misinformation in the context of the election if there's actual malice. And this gets struck down saying, because there's a less, using strict scrutiny, there's a lesser restrictive alternative. The court in the circuit says there's always a lesser restrictive alternative, which is more speech. So, one way to look at this is still New York Times versus Sullivan, right? Because you could make the same claim about New York Times versus Sullivan. If I defame you, regardless of election, there's always the lesser restrictive alternative. Well, come back, whatever. So, once you frame these things outside of the logic of why you're protecting and not protecting, and have this abstract categories like lesser restrictive alternatives, you can go everywhere and nobody can expand that far with disinformation. The court will have to retreat a good deal from disinformation.
One of the reasons for that, what I mentioned earlier, is this is the context in which if we talk about government constitution, You should not trust government to decide which false statements political discourse to punish, because they will not be even-handed about it in many jurisdictions. Imagine the Trump administration, for example, if they had the power to punish with either actually false speech or what they claimed is false speech, they would be very biased. And maybe the Biden administration would do that as well. In many states, they would not be even-handed. So the problem is not that false speech is valuable in that context. It's not. But it's that we just don't trust the government to decide who to prosecute or not.
So can I just mention? Sure. So the campaign candidate that sends out flyers to the people in a poor neighborhood gives them the wrong day of the election, the wrong polling place, and you wouldn't trust the government whether or not to prosecute them.
I would think such speech is horrible. I agree. No, because again, I think that we depend a lot on what jurisdiction you were in, what the figures were. I just don't trust political people in power in government, especially not this generation. So no,
I just gave you these, there was a Supreme Court case, I'll be honest, called Susan B. Anthony versus Dreyhouse that involves an Ohio law that did false speech, and the Supreme Court found it to be right for review, or it wasn't moved, then struck it down. So they had to back away from that. My instinct is to agree with Jack of being afraid of giving the government the power to decide what's true and what's false in an election can be prosecuted. Though I now less sure than I used to be about that because of internet and social media and the enormous prevalence of false speech and the harm that it causes, my skepticism that more speech really works in the context of the election. So I'm torn between where you come out and say, I just don't want government power to decide what's true, what's false in an election, and say, how do we deal with this huge problem of false speech over social media and the internet?
I mean, I think the answer to both Robert's question and this comment is that you need to find a way to be able to trust the government to prosecute neutrally. And the way to do that, theory, would be to have a bipartisan committee that makes the decision whether to prosecute. And
Like the FCC.
You got it right. The FCC is not you would do before court. It's bipartisan. So I think if you had an even number of people, then they would be less likely to be partisan in the decision. And they may not do anything because they're going to react for whatever it is to agree. But that's the only way I would consider it. Otherwise,
so if you want to just point here, if you want to consider why government in the United States has collapsed, consider that it gets attacked from the right. The right doesn't like big government, it doesn't approve government regulations, and it attacks people on the left. We don't trust the government to do this, that, and the other. So if no one trusts the government to do anything, get the government to serve.
Next question.
Oh, thank you. Really, really fascinating. Gentleman Berman, don't you think that ultimately the concept that these rules will prevent ambiguity really overlooks that there's a presumption in your premise that these rules are being applied consistently and are in fact being don't have ambiguity in and of themselves. In particular, if you look at a test like the most exacting scrutiny and exacting scrutiny, which it goes all over the place. It sometimes uses least restrictive, it sometimes uses narrowly tailored, and sometimes the rules are just not applied in anything where you could say very well, securities regulation should be found in the Constitution. So isn't the premise that the rules will be applied consistently across the board, can be applied consistently, when in reality, when we look at it, even categories, for example, of the government speech rule, they're not really applying rules, but rather they're applying rules in a particular setting and based on particular proclivities of the justice. And Robert, wouldn't it be, in terms of the breadth of coverage and analysis, where, by the way, my article is just that Breyer is not ad hoc because he has the specific method. Is considered the speech involved, then how to weigh the government concerns, means ends considerations, and whether there are alternatives for insertion that is deeper actually than the European Court of Human Rights. I think it's deeper and more more rigorous than the European cases, in fact. But what about just looking at the principles of the Constitution rather than deliberative democracy? And deliberative democracy as being one of the critical considerations, whether the value is free speech, but so too is personality, so too is the marketplace of ideas. So for example, if I'm standing in the shower and I'm singing something against some political party, no person hears me, no person, I have no effect on anything democratic, nothing artistic to it. I have a terrible, terrible voice, trust me. But yet it seems free speech, and if we think of George Orwell's type of system, which we're pretty close to, we can certainly create with today's electronics. And Apple watchers do in fact listen to people. We have whistleblowers that say they listen to people having sex on the other end. And so, the government can tap into that by paying no state action, just pay Apple to give you that information, you don't get that. Then the worry is that even in my private shower, where I'm not affecting politics, not affecting democracy, that there seem to be greater values that might be at stake, that called free speech constitutionalism. The final thing I just would say, and I just would link this, is the questionable validity of even saying that the word is used in tradition, history, and in text, in where it says very clearly that we're using history and text, which is Stephen's case that says, we got obscenity and pornography, child pornography, fighting. Well, none of those are historic categories. They didn't exist until the 20th century. So the critical thing is really formulating an argument here, rather than thinking that there's something truly objective that was doing is passage of tradition.
So on the first point, you're absolutely right that the existing categories are often vague and unpredictable. But I do think they have a serious effect on how lower courts and lawyers advise people and decide cases. So there are always going to be marginal cases, no matter what the rule is. And that's going to be ambiguous. But I think if you compare that to a more open-ended approach, this enables a lot more certainty and a lot more predictability than would be the case otherwise. And I think that certainty and predictability is very important to the ability of people to engage in free speech. Just as I said earlier, the fear of being punished for engaging in speech will deter an awful lot of speech, because what individuals gain from speaking is not a whole lot of it. And I think the reason for having categories, we try to have as much clarity as you realistically can, without going really overboard, is to avoid both government bias in terms of how they enforce the categories of the law, and enabling people to have a reasonable degree of confidence in whether what they do or don't do is subject to punishment in the speech area, mainly because of the chilling effect problem and the danger of government misusing the ambiguity to punish speech that they don't want. So I agree with you that all these doctrines, except maybe viewpoint discrimination, have all sorts of ambiguities, but they're much better than an open-ended approach that would not give that degree of predictability.
I was going to say the same thing. The fact that rules often have ambiguity and often are inconsistent doesn't mean that they're always ambiguous and always inconsistent. And it doesn't mean that they still don't serve a function, especially in terms of how lower courts, state and federal, have to deal with things. But you mentioned exacting scrutiny, so I'm just going to focus on that. This is a place where I would be very critical of the court for its imprecision. In America's Prosperity versus Bonds a year ago, Chief Justice Roberts said, exacting scrutiny finds it substantially related to a sufficiently important government interest. I don't know how that's different than an immediate scrutiny, which is substantially related to important government.
Each language is a narrow feeler at the end.
Right, but I don't know how it's different from an immediate scrutiny or why he feels the need to create exacting scrutiny. There's nothing magic about the creatures of scrutiny.
There could be a fourth, but I don't see how this is that. And to me, we should be critical if you believe there's any value to levels of scrutiny, and that either using the existing ones or justifying the creation of a new one.
I think the question that you asked goes to public and private. I think that's what you asked me. There are, if you think about the threat that the internet poses to modern free speech doctrine, there are many threats, but here are two that are enormously significant. When we think about freedoms that when we think about freedom of speech, almost all people theorize it in terms of the relationship of a demos to its government. So you speak so that the government can be responsible one way or another. And so that's imagining of the national public sphere, but the internet is international. And so what are we protecting and how do we protect it? No one knows, but we don't realize that at all. That's one problem. The second problem is almost every system of freedom of speech regulation, which I'm familiar with. Vicky Jackson tells me this is not true anymore. It's true now. But it makes a distinction between speech of public concern and private speech. Think of defamation. If you're speaking about a matter of public concern, the First Amendment gets involved. If you're speaking about a private person, about a matter of private concern, the common law can do it. Some distinction like that is at the root of almost every constitutional system that protects freedom of speech. So the notion of a public-private distinction is crucial to the architecture of free speech protections. And on the internet, we don't know what that means. We don't know, you have a group of your 250 closest friends on Facebook, and you make a post to them. Is that public? Is that private? The inability to understand what's public and private on the internet and make this distinction is extremely unsettling, in my view. The First Amendment doctrine and how we think about the architecture and structure of our protections, and we're not going to be able to clarify it until norms of practice emerge, in which we instinctively begin to settle for ourselves what is in fact private on the internet and what is in fact public, and it's changing so fast. It's very hard to know what those distinctions mean.
I'm really sorry. We're going to have to end this dream session. I cannot thank you all enough. Thank you, and please join me in.
Today has been so informative, so incredible, and so much fun. So thank you to our last panel, to Professor Copandrea for moderating. It's been such a wonderful day, and first I want to say that I'm so thankful that we were finally able to gather in person to have this event, to reunite friends, and to have these important conversations. Today has been filled with so much incredible discussion, and in the wake of Justice Breyer's retirement, it's so important to talk about the mark he leaves on our First Amendment protections. I'm so thrilled that today we were able to hear about praises, critiques, and much thoughtful discussion about Justice Breyer's First Amendment jurisprudence. I'm sure I speak for more than just myself when I say that hearing each of our panelists' unique positions on these core issues is beyond inspiring, and hearing and learning from the First Amendment greats in this room is an experience that I truly will never forget. Time will tell how or if Justice Breyer's jurisprudence, whether it's viewed pragmatically, problematically, or a bit of both, will live on. But for today, I'm glad to have had just a small part in our conversation on where Justice Breyer stands on these issues and where his position could inform future debates and challenges of the First Amendment. Thank you again so much to all of our panelists and our moderators for participating in this event and for imparting your expertise and your wisdom on all of us. We're so lucky to have you here, and we hope that you'll come back soon. Thanks again to our advisors, Professor Muffindray and Professor Ardia, for all you've done to help this event be a success. Thank you so much to the Carolina Club for hosting us today and to all of our sponsors. And so now I'm going to turn it over to Kendall to close us out. Thank you all.
I think Rachel generally took care of it. I can't say it any better than that. I really just want to again stress how important it is that you came for CLE credit, that you touch base with the people at the table who'll be out there as we now. We really need your information so that we can ensure that you get the credit you came for. Also, if you're on the live stream, like I mentioned earlier, I'll be following up with you after this event to get what I need from you so that you can get your CLE credit. Again, thank you all so much for coming. This was a great event. I can't thank you enough.